this session of Civil Superior Court, a specially convened session of three-judge panel appointed by the Chief Justice to preside over this matter. We're calling for trial the matter of Common Cause et al. Versus Representative David Lewis in his official capacity et al. 18 CBS 14001. A couple housekeeping matters as we get started this morning. First of all, we welcome all of you to this courtroom. We're delighted to have participation of not only all the lawyers but also citizens in this open court that we have. Earlier this morning, I convened court in courtroom 701 of the Wake County Justice Center and entered an administrative order in my role as senior resident Superior Court Judge of Wake County, finding that our facilities, although they are new and wonderful facilities, are inadequate for commencing a three-judge panel, primarily because we don't have courtroom facilities where three judges can sit at a bench and preside. So that is why we have designated this courtroom as a courtroom of the Wake County Superior Court for the purposes of this trial. The second thing I'd bring to your attention is that at some point today we have a link that is available on the Administrative Office of the Court's website that will contain, I believe, over 90 filings, pleadings, briefs, exhibits, etc. that have been submitted in this case throughout its history. We've received input from counsel. I believe that all of the files that we intend to publish are ones that there's no objection to being made public at this stage. There are about 5 or 6 documents that have been withheld simply because they contain confidential proprietary information that was submitted under seal. It may be during the course of the trial that those files are made available as well once we've had an opportunity to obtain either consent of the parties or hear any objection to it. That site will be made available live to any member of the public, any member of the media. If you wish to have the URL for that site, our clerk, Sarah Fisher, will have that URL available, so just simply come up during one of the breaks and recesses and you're welcome to obtain that information. What we'd like to do to get underway is first begin with just a introduction of all of the counsel that's involved here today, so that if we could just start with the plaintiffs and have you introduce yourselves for us, and we'll go ahead and make a list of all the counsel that will be participating.
Yes, thank you, Your Honor. Stanton Jones from Arnold and Porter for the plaintiffs. I'm joined by Eddie Spees, Caroline Mackey, and Steve Epstein from Pointer Spruill, and also several of my Arnold and Porter colleagues, Elizabeth Theodore and Daniel Jacobson, whom you know, as well as David Gersh, Bill Perdue, John Robinson, John Stella, Sarah D'Amico, and Sam Callahan.
All right, thank you, sir. All right, moving to the legislative defendants, Mr. Strike.
Good morning, Your Honor. Phil Strack, Ogletree Deacons for the legislative defendants. I'm joined here today by my colleagues from Baker Hostetler, Kate McKnight, and Mark Brady, Patrick Lewis, and Erica Crowdy. And I'm joined by my colleagues from Ogletree Deacons who are in various spots in the courtroom, Alyssa Riggins, Michael McKnight, and Brody Irwin.
All right, thank you very much. For the intervening defendants, Mr. Branch.
Good morning, Your Honor. John Branch, Shanahan Law Group, here on behalf of the intervener defendants. I'm here with my colleagues Nate Pincook, Andrew Brown, and Cassie Holt, who is a summer associate in rising third year at Campbell Law School, who's also here with us.
Very good, thank you.
Thank you.
And then for the state of North Carolina, I know we have a notice of appearance. Yes, sir, Mr. Tolchin.
Yes, Your Honor. On behalf of the State Board of Elections and the officials and individual members of the State Board, Matthew Tolchin from the North Carolina.
Thank you. All right, I believe that is the Yes.
If I might amend our list and have Tom Fawn from OT.
All right. Very good. Thank you. All right. I know there are folks standing in this courtroom. That's fine with us. Unless the fire marshal comes, we're fine with folks standing. These proceedings are expected to last several days. If you are uncomfortable standing, I believe that room 313, I believe, is an overflow room. 311 or 313, I'm not sure. Either one. 313 is an overflow room. I believe these proceedings are being live streamed in that room, so you're welcome to make yourself comfortable there if you wish. But we're glad to have you here as long as you care to be with us.
So for if I may,
Yes.
today the overflow is in 312.
Thank you, ma'am.
There's an exam in 313.
All right.
The rest of the time will be in
Right, so 312 is the overflow room, which brings to mind another matter. I think it's about 2 weeks away from the state bar exam. There will be a lot of law students or graduate Juris Doctors around this building who will be looking anxious and who will be upset if you disturb their studies. They are working very hard for the bar exam. So please be very respectful of their space and their time. The rooms that we designated, you're welcome to use. There's a common area on the second floor where there's a snack bar and a lot of space to sit and confer. You're welcome to use that. But please don't just enter into classrooms that are not designated for our use. It may be that either students are studying there or doing bar prep activities. All right. I believe we're ready to proceed. We've received a number of documents over the weekend and the last several days, so we'll allow the parties to orient us to all of that. But I believe we're going to start with opening statements from counsel, and then we'll proceed directly into the evidence. We'll hear first from the plaintiffs. Mr. Jones.
Thank you, Your Honors. I'm Stanton Jones from Arnold and Porter for the plaintiffs. I've already introduced all the lawyers on our side. I'm also pleased to introduce today several of the plaintiffs who are here. For Common Cause, Bob Phillips is here, and you'll hear from Mr. Phillips as our first witness this morning. For the North Carolina Democratic Party, Wayne Goodwin will be here, and you'll hear from Mr. Goodwin this week as well. We're also joined today by 5 of the individual voter plaintiffs, and they are Amy Oseroff, a teacher from Greenville, Derek Miller, a professor of German from Wilmington, Ann McCracken is a retired English instructor from Sanford, Joshua Brown, a locksmith apprentice from High Point, and Becky Johnson, a retired teacher from Winston-Salem. You'll hear live testimony this week from Mr. Miller and Mr. Brown, and we will submit testimony from the other 35 voter plaintiffs in this case through written affidavits. I'd like to take about 20 minutes this morning for opening remarks. I will address what this case is about and what the evidence will show. I'll hit the high points of our legal claims, and I will address a few of the refrains that we expect you will hear from the defendants. This case is about how North Carolina's legislative districts have been drawn intentionally and systematically to help Republicans win and to minimize the political power of Democratic voters. Republicans in the General Assembly have manipulated the district lines to guarantee that their party will control both the state House and the state Senate, regardless of how the people vote. This attack on representative democracy and voting rights is fundamentally unfair. And it doesn't matter which party does it. It's wrong. It violates the North Carolina Constitution, and we're asking the courts of this state to bring it to an end. The evidence in this case will establish conclusively that the current state House and state Senate plans are extreme partisan gerrymanders. Some of the gerrymandered districts were drawn in 2017, and others were drawn in 2011 and kept in place in 2017 without change. But the evidence will show that at both points in time, legislative defendants acted with discriminatory partisan intent. The story of how we got here isn't complicated. Back in 2011, working in secret, legislative defendants' mapmaker, Dr. Hoffler, drew House and Senate maps designed to lock Republicans in power in the General Assembly for a decade. And their plan worked. In 2012, 14, and 16, Republicans won veto-proof supermajorities in both chambers of the General Assembly. Legislative defendants have openly admitted that the districts drawn in 2011 were, quote, designed to ensure Republican majorities in the House and Senate, end quote. They said they were perfectly free to do so. So that tells you about the districts that were drawn in 2011 and kept in place in 2017 without change. In 2017, federal courts struck down some of the 2011 districts as illegal racial gerrymanders. At that point, legislative defendants should have undertaken a transparent process to draw new maps in public view with public input. They should have drawn fair maps that would allow voters, for the first time this decade, to cast their ballots in free and fair elections. But instead, they worked in secret. Legislative defendants and Dr. Hoffler redoubled their efforts to gerrymander the district lines along partisan grounds. There isn't any real dispute about what happened. Dr. Hoffler used elections data to gerrymander the maps for partisan gain. In the official criteria for the 2017 redraw, legislative defendants told Dr. Hoffler to use political considerations and elections data. There was no ambiguity about what they meant. This was an unequivocal direction to Dr. Hoffler to draw the maps to advantage Republicans. Republican legislators adopted this elections data criteria on a straight party line vote over the opposition of every Democrat. And when Democrats proposed an amendment to prohibit the pursuit of partisan advantage in the 2017 redraw, Republicans rejected it again on a party line vote. Dr. Hoffler delivered. Our experts will show by a host of mathematical and statistical measures that the 2017 plans are outliers. Their extreme partisan bias is an outlier that could only be the product of partisan intent, a deliberate effort to solidify Republican political power by manipulating district lines. If there were any lingering doubt, we will present direct evidence from Dr. Hoffler's own files that he used elections data to intentionally gerrymander the 2017 plans, just as legislative defendants wanted. Dr. Hoffler's files prove beyond a doubt that partisan gain was his singular objective. This gerrymandering of the 2017 plans was systematic across the state. Our expert, Dr. Christopher Cooper, is head of the political science department at Western Carolina University. He will explain county cluster by county cluster how Democratic voters were packed into heavily Democratic districts and also cracked across the remaining districts to ensure a reliable Republican majority in each district. Once again, their plan worked. People's votes should matter, but these plans were drawn so that they overwhelmingly don't. 2018 was a Democratic wave election. It was big enough to break the seawall that Dr. Hoffler designed to secure Republican supermajorities, but even the 2018 wave couldn't overcome the stronger seawall that legislative defendants put into place to guarantee themselves at least a majority in both chambers. The simple truth is this: because of the extreme gerrymandering, Democrats cannot win a majority in either the House or the Senate under the 2017 plans. So when it comes to control of the General Assembly, these plans are impervious to the will of the voters. And that has real consequences. It means that Democratic voters will never have a seat at the table in determining the state's laws. Those voters will never get any meaningful say on the kitchen table issues that matter most to them. And that's no accident, as our experts will show. These plans were gerrymandered very specifically to prevent Democrats from winning a majority in either chamber of the General Assembly. The North Carolina Constitution prohibits partisan gerrymandering. The state's Equal Protection Clause provides stronger protection for voting rights than the federal Constitution. And specifically in Stevenson v. Bartlett, the North Carolina Supreme Court said, in the context of redistricting, that, quote, in this state, the right to vote on equal terms is a fundamental right, end quote. There is nothing equal about the terms on which people vote for House and Senate candidates under these 2017 plans. North Carolina's Constitution also commands that all elections shall be free, a provision that has no counterpart in the federal Constitution. But elections to the General Assembly are not free when the outcomes of both individual races and control of the General Assembly itself are virtually predetermined by partisan actors sitting behind a computer. The North Carolina Constitution's free speech and assembly guarantees also prohibit the government from intentionally discriminating against voters because it disfavors the political beliefs that they express through their votes. Unless the courts step in, this will keep happening. One partisan gerrymander will lead to another in a perpetual cycle. Because the governor can't veto redistricting legislation, the General Assembly alone will control the next round of redistricting in 2021. So these Republican majorities elected under the current gerrymanders will have free rein to enact new gerrymanders to maintain their control of the state legislature for 10 more years. Only the courts can end this cycle and ensure free and fair elections in 2020. Throughout this trial, you'll hear a few consistent refrains from the defendants, but none of them is right. You'll hear that the U.S. Supreme Court recently closed the door to partisan gerrymandering claims in federal court under the federal Constitution. But in doing so, the Supreme Court specifically recognized that state courts applying state constitutions may still invalidate partisan gerrymanders. And that's as it should be. The U.S. Supreme Court explained long ago that state courts are free to serve as laboratories of democracy, and that state courts must be left free and unfettered by the U.S. Supreme Court to interpret their own state constitutions. State courts do not need to sit idly by while people's constitutional rights are being violated just because the U.S. Supreme Court refuses to act. The North Carolina Supreme Court has said that the state constitution protects voting rights even when the federal constitution does not. And indeed, when it comes to protecting democracy itself, the absence of any federal remedy is exactly when it is most essential for the state's own courts to step into the void. You'll hear from the defendants that plaintiffs' claims seek proportional representation. But make no mistake, plaintiffs are not seeking proportional representation. Instead, we are seeking to prevent the General Assembly from intentionally discriminating against voters on the basis of their political beliefs and their past votes, to prevent the General Assembly from drawing legislative maps deliberately to predetermine the outcome of elections before people vote. Plaintiffs as experts will identify these maps as extreme partisan gerrymanders through statistical and mathematical methodologies that do not rely on proportional representation, not at all. You'll hear that North Carolina's whole county rule and the official adopted criteria supposedly prevented Dr. Hoffler from gerrymandering, or at least from gerrymandering very much. But as you'll see from Dr. Hoffler's own files, as well as our experts' analysis, North Carolina's redistricting rules left Dr. Hoffler plenty of discretion to gerrymander the maps for partisan gain, and he took full advantage. You'll hear that it was the Democrats' fault they couldn't win a majority in 2018. But that isn't right either. 2018 was about the most favorable election environment you can imagine for Democrats. They had more money than Republicans, a blue moon election, better candidate recruitment, enthusiasm generated by the actions of the Republican supermajorities, a Democratic wave nationally. But even with all that, the 2018 wave still couldn't overcome the seawall of the Republican majorities in both chambers of the General Assembly. Lastly, you'll hear from the defendants that map makers from both political parties have long sought partisan advantage in drawing districts. They will claim that partisan gerrymandering is old, so it must be okay. But a historical pedigree is no reason to perpetuate discrimination against voters. For decades, mapmakers devalued people's votes by drawing districts of unequal population until the courts prohibited it. Legislatures used to freely engage in racial gerrymandering until courts prohibited that too. The North Carolina Constitution doesn't have any grandfather clause for rigging elections. Voters are not chess pieces to be moved around on a board in some political game. They are citizens of this state. They have fundamental rights under the state constitution to fully participate in choosing the representatives who govern them. And those rights deserve to be recognized and enforced. We ask that this court invalidate the 2017 plans under the North Carolina Constitution and order new fair maps for the 2020 elections. Then, and only then, will voters get to cast their ballots in free elections on equal terms as the state's constitution requires. We look forward to presenting our case this week, and we thank you.
Opening statement for the legislative defendants. Mr. Strack.
Thank you, Your Honor. May it please the court. Let me be clear. This lawsuit is not about protecting democracy. It is a full frontal assault on democracy. What the plaintiffs are asking this court to do is to exercise raw judicial power to remove redistricting from the legislature and hand it over to the courts. And not just because they want you to decide this case without any standards, which we'll talk about. It goes much further than that. They're asking this court to create a new redistricting process that would normally require legislative action or even a constitutional amendment and a vote by the people. It's hard to think of anything less democratic than to ask a court to do by judicial fiat what the plaintiffs have been unable to do through the political and legislative process. And what I'm saying here is not hyperbole. This is what the evidence will show the lead plaintiff wants this court to do. The lead plaintiff, Common Cause, has already testified in this case by deposition that it doesn't even know which districts it's challenging. It's testified that it doesn't know whether it's challenging every district in the map. Instead, it will admit that it is challenging the process of redistricting. And what it is doing is using a court case against the map as the vehicle to do that. So what the plaintiffs here really want is for this court to undemocratically change the redistricting process and remove it from the legislature where it is constitutionally assigned. So make no mistake, plaintiff's problem in this case is not really with the maps, and that's for good reasons. First, the Stevenson rules that the court is familiar with greatly constrain the legislature's discretion in redistricting. The Stevenson rules and the other constitutional rules that apply here draw the map. They draw most of the map. Here, 63% of the state's population was redistricted in the Senate map by the Constitution itself. 63%. 90% of the counties in the Senate map were drawn by the Constitution. Over 70% of the counties in the House map were drawn by the Constitution. Even the maps drawn by Common Cause and the Covington plaintiffs have significant overlap with the enacted plans. So the Stevenson rules limit the political decisions that can be made. Let's look, Your Honors, at the 2001 redistricting plan. And we're going to put it up on the screen. Your Honors, hopefully the technology will work. But I've got copies for the judges. Your Honors, this is a copy of the 2001 Senate map drawn by the Democrats when they held the majority in the legislature. This map was drawn prior to the existence of the Stevenson rules. And if you look at this map, there's more than 50 split counties, and there's numerous irregular districts. For instance, the court can just look at Wake County, where there is a district, it looks like 13, that starts in southern Wake County and winds its way up to Durham and into Granville County. There's a district that's in Forsyth County that looks like a mini version of the infamous 12th district that was drawn for the North Carolina Congress. There are numerous irregular districts in and around Mecklenburg County. Your Honor, this map would be illegal today. And in fact, this very map was struck down by the state Supreme Court. The county grouping and the traversal rules now limit the ability for any party to draw a map that looks anything like this. Now I'm going to ask the court to look at a map that we will introduce from one of our expert witnesses in this case. Your Honors, this is a map that our expert drew, which is essentially the Republican version of the 2001 Senate map that I've already handed up. Again, what you see are split counties all over the map. You've got numerous irregular districts throughout the map. And just to highlight one particular area of the map, I'm going to hand the court up a close-up of the Mecklenburg County area, because I want the court to understand how the Stevenson rules limit the political discretion that the legislature has in drawing these maps. This is a close-up of the Mecklenburg County area in our expert's map. And as the court can see, numerous districts reach into Mecklenburg County and then go outside of the county in order to draw districts that would now violate the Stevenson case. Under the Stevenson rules, Mecklenburg County this decade has to be one grouping. All the districts have to be drawn within the grouping. So the legislature does not have the discretion to use Mecklenburg population and combine it with populations outside of it to draw districts that one might perceive to be benefiting Republicans or Democrats. This configuration of this map is illegal under the Stevenson rules. So what the evidence is going to show is that the Stevenson rules and the mid-decade redistricting rule in this state take many political decisions off the table. And the evidence will show that the legislature scrupulously followed all these rules. Next, Your Honor, the evidence will show that Democrats can win under the 2017 plans. It's just false that they can't. They have a tremendous registration advantage. The evidence will show that if you add up the registered Democrats and unaffiliated voters, the Democrats could win 169 out of 170 of the legislative districts with 0 Republican votes. Not one vote from a registered Republican. Then, Your Honor, there's the evidence of the Democratic Party's support scores, which the court is familiar with because we had to litigate whether they would even turn that information over in this case. This is the Democrats' own political data. This is how they measure whether they can really win a district or not. So this is their own data. Their own data shows that they can win majorities under the 2017 plans. In fact, their own data is going to show, and this court's going to see, that they can win supermajorities under the 2017 plans. So the plaintiffs repeatedly claim they are shut out and can never win back the legislature. This evidence alone simply demonstrates that is not true. What the evidence shows is that what they really want is the court's help in electing Democrats rather than having to recruit the kind of candidates that could turn their support scores into reality. Your Honor, there's been talk of expert evidence. The plaintiff's own expert evidence will actually undermine their claims. One of their experts will be Dr. Chin. His evidence will show that the plaintiff's claims here are pure exaggeration. Dr. Chin's analysis says that the Democrats can only win around 46 seats under the 2017 plans. Wrong. Guess what? They won 55 seats. So Dr. Chin's analysis right off the bat is off by nearly 10 seats. The Democrats in the 2018 election got a little over 51% of the statewide legislative vote. Not even Dr. Chin says that that would be enough for the Democrats to get a majority in the legislature, even under his so-called nonpartisan simulated maps. The plaintiffs will claim that because they got a little over 51% of the vote, Democrats should have gotten a majority. That is simply ahistorical and not true. The evidence will show many examples in this state of one party or another getting a majority of the votes, but not a majority of the seats. And there's good reason for that. We do not have a proportional representation system. And pleas by plaintiffs in courts to implement such a system have been denied again and again because the court is the wrong forum to enact such a change. in North Carolina, it's also not surprising that the Democratic Party would get a slim majority of the statewide vote and not win a majority of the seats. In recent decades, the evidence will show that the Democratic voters have increasingly clustered themselves in urban areas, and Republican voters are more geographically dispersed. Even plaintiffs' experts will concede this gives Republican legislative candidates an overall advantage. So, if the Constitution draws most of the map, and the Democrats can in fact win majorities under the map, what's the problem? The plaintiffs aren't going to answer that question. They're going to complain that the legislature used election data. But the North Carolina Supreme Court has already decided this issue. In the Stevenson case, the North Carolina Supreme Court expressly allowed this. It said the legislature may consider partisan advantage and incumbency protection in the application of its discretionary redistricting decisions. This question has been put to rest a long time ago. At a minimum, the plaintiffs are going to want this court to try to overrule that language by the Supreme Court. But even on this, plaintiffs' evidence will be contradictory. On the one hand, they'll complain that Democrats got 51% of the vote, but not a majority in the legislature. Of course, that sounds a lot like proportional representation. But they will also complain about, say, the Mecklenburg County House districts, where Democrats won every single district in 2018, even though there are large swaths of Republican voters in that county. So the plaintiffs want proportional representation when it benefits them on a statewide basis, but not when it doesn't inside the county groupings. On the one hand, the plaintiffs will complain that the districts should be more competitive, whatever that means. But then they will also complain that, for instance, the Wake County House districts were too competitive, that the Democrats had to work too hard to win every single one of them. So competitive is going to be good when they want it to be good, but bad when they want it to be bad. The court is going to be stuck in the middle of this incoherent evidence. But the plaintiffs won't give the court any help in finding a standard by which to judge their incoherent theories. When is a district too competitive or not enough? Is there a point at which the permissible use of partisan advantage allowed by the state Supreme Court has veered somehow into something impermissible? Plaintiffs will not even attempt to give the court any standard that answers any of these questions. Their experts will admit that they've not tried to answer that question. There will be lots of discussions of outliers, but if the 2017 maps are supposedly a partisan outlier, where is the line between a map that is not an outlier and one that is? The expert witnesses in this case for the plaintiffs will refuse to answer that question. They don't know the answer to the question because it's a question that is unanswerable. How do you legally judge voters' voting preferences? How do you know what is a fair map politically? There is no way to know what a fair map looks like. The only way that you can do that is to impose by judicial fiat some notion of fairness. That would require the court to decide essentially how many Republicans and Democrats should be in the legislature. That is obviously a political issue, not a legal judgment. The plaintiffs here will give you nothing that will help you make a legal judgment about what a fair map looks like. They will ask you to make a political decision. I can't think of a more dangerous threat to democracy and the courts than the political judgments that the plaintiffs are going to be asking this court to make in this case. And making political judgments is entirely unnecessary. Article 2 of the state constitution, as interpreted by the Stevenson rules, already spells out the specific rules for redistricting legislative districts. There will be no dispute that the legislature followed all of those rules. So that should be the end of the case. Instead, plaintiffs are asking you to apply an amorphous theory from amorphous provisions of the state constitution to override Article 2 of the state constitution. But in addition to the threat these claims pose to the integrity of the judicial system, if the court agrees with these amorphous theories, they won't just apply to the legislature. They will apply to all units of government that elect members by districts, county commissioners, city councils, school boards. There are hundreds of these districts around the state. Does this court want to be the new partisan redistricting court? All plaintiffs have been able to muster, Your Honors, is an attempt to create a boogeyman out of a dead map drawer who drew maps in this state. Anytime you hear the name Hoffler, know that this is a sideshow by plaintiffs attempting to distract you from the weakness in their case before you. At the end of the day, the plaintiff's presentation and evidence in this case is nothing more than an invitation to follow the flute of the Pied Piper into a thicket full of thorns. There is no need to enter the thicket under our current constitutional order. The state constitution and the Stevenson rules already provide justiciable standards balancing the use of neutral criteria and partisanship in redistricting. The court should resist the flute, avoid the thicket, and uphold the constitutional order by dismissing these claims. Thank you, Your Honor.
Thank you, Mr. Stroud.
Mr. Branch, on behalf of the intervening defendants.
Good morning, Your Honors. May it please the court. My name is John Branch with Shanahan Law Group. I'm here today on behalf of 7 individual intervener defendants in this case. These individuals are registered Republicans who regularly vote for Republican candidates in General Assembly races, and they are active in state and local politics. In many ways, they are much like the individual plaintiffs here, except they are Republicans instead of Democrats. Interveners are normal people who, the evidence will show, live in a number of legislative districts that will be affected in the event that the court awards the remedies that the plaintiffs seek. They are normal people who were so concerned with what the plaintiffs are trying to do, take the discretionary redistricting political power away from the legislature, that they decided to seek to intervene in this lawsuit as defendants. During this trial, the intervener defendants will help demonstrate that much of the basis for plaintiffs' claims that the district lines were illegally drawn is wrong, and that the harms plaintiffs claim to suffer are exaggerated at best and often non-existent. Interveners Adrian Arnett, Kathy Fanslaw, and Aubrey Woodard will present evidence that they are Republican voters that live in Wake, Transylvania, and Lenoir counties, that they customarily vote for Republican candidates for the General Assembly, and that they prefer a Republican majority in the General Assembly, much like a number of the individual plaintiffs. The evidence will show that intervener Connor Gross, who's a sophomore at UNC, has lived his entire life in Clemens, North Carolina. He believes that the way that the district lines are drawn in Forsyth County, which generally keep Winston-Salem whole to the extent possible allowed under the equal population rules, respects the distinction between rural and urban communities in that area. The evidence will show that Carolyn Elmore, a longtime resident of Harnett and Cumberland counties, and someone who has been active in state and local politics for decades, believes that the quality of candidates up and down the ballot, not just the legislative candidates, can affect and has affected the results of the legislative races on which she has worked. The evidence will also show that Reginald Reed, who lives in Forsyth County and in the city of Winston-Salem, and who's been active in grassroots and local Republican Party politics for years, twice ran for state legislative office knowing he had an uphill battle to win the election since he lives in an area densely populated by Democrats. The evidence will show that the makeup of Mr. Reed's district did not impact his choice of where to live, that nothing prevents Mr. Reed from exercising his rights of freedom of speech or of association, and that he is represented
by his state senator and representative at the General Assembly, despite the fact that they are members of the political party that he does not support and take policy positions with which he does not agree. The evidence will show that Ben York, a public servant living in Alamance County who is also the chair of the county Republican Party, believes that the House districts in Alamance County respect the communities there, and that contrary to plaintiffs' claims, he believes that the electoral outcomes in Alamance County have more to do with the quality of the candidates as opposed to down which street the district lines are drawn. Though interveners' evidence certainly contrasts with plaintiffs' claims regarding the makeup of the districts in which they live, more importantly, it crystallizes one of the fundamental problems with plaintiffs' argument. They are asking the North Carolina judiciary to grant itself the ability to pick sides in what is a political dispute between Republicans and Democrats. So make no mistake, the plaintiffs are attempting to take the political decision of where the district lines are drawn out of the hands of the General Assembly, the branch of government the Constitution specifically designates to make such a decision. When the legislature draws maps, it makes law. The evidence will show that the Stevenson rules and the other constitutional requirements provide powerful limitations on the General Assembly's map drawing abilities. These rules are nonpartisan limitations on redistricting with a textual basis in the Constitution. They provide clear standards through which the courts meaningfully check the General Assembly without supplanting it. In addition to these rules, though, plaintiffs are asking the court to create a new judicial standard to determine when a political act performed by a political branch, which is implementing a political function, is just too political. Tellingly, plaintiffs cannot even suggest what that standard should be, and indeed, under the definition of free and fair elections advanced this morning, no legislative election ever conducted in the state of North Carolina has been free or fair. Outside of Stevenson and the explicit constitutional limitations on redistricting, the General Assembly, the lawmaking branch of government, has ultimate authority on making the law. Drawing the maps is constitutionally and logically a legislative and political function. It is and should be performed by politicians subject to the electoral process every 2 years. And again, make no mistake, the evidence will show that Democrats can win a majority under these maps that are being challenged. They claim that a purported blue wave in 2018 should have carried them into majorities in the General Assembly, but only the legislative district lines kept them from winning the majorities. The evidence, Your Honors, will show that if there was a national blue wave in 2018, in North Carolina, we merely felt a blue swell. While Democrat Party vote share numbers were up, they barely passed 50%, and that for the first time since 2008. I would ask the court to contrast the 2018 margin to the 2010 elections, in which the Republicans won almost 60% of the vote share for the General Assembly. A 2% victory margin is not a wave election. A 20% victory margin is a wave election. What is more, to break 50% vote share and fail to win a majority of the legislative seats is hardly an anomaly in North Carolina politics. Dr. Michael Barber, intervener defendant's expert witness, will testify that from 2000 to 2006, when the redistricting lines had been drawn by Democrats, 5 times out of 8 elections, Republicans won a majority of the vote share for one of the 2 houses of the General Assembly, and yet they did not win majorities in those houses. In all of the redistricting litigation that happened then, no North Carolina court held that such a difference between a political party's vote share and their seat share in the General Assembly would be sufficient to read into the Constitution a prohibition on the General Assembly considering election results and politics in drawing the district maps. Yet, Here we are today with the plaintiffs asking the court to do just that. At the end of the day, our Constitution is explicit both with regard to who conducts redistricting and what restrictions there are on it. Article 2, Sections 3 and 5 state that the General Assembly shall revise the Senate and the House districts and the apportionment of senators and representatives subject to the listed restrictions contained in those sections. Consideration of election results and political factors are not included in the constitutional restrictions, even though they have been part of the redistricting process for hundreds of years. With the goal of removing the lawmaking function of redistricting from the General Assembly, which is controlled by the opposition party, plaintiffs ask the court to read into the Constitution a new rule that is not and has never been there. Plaintiffs will not be able to show a legal or factual basis for the creation of such a new rule, and the court should thus dismiss plaintiffs' claims in their entirety. Thank you.
Mr. Tolchin, do you wish to make an opening statement on behalf of the state?
No, Your Honor, thank you.
All right, thank you. All right, we'll move into evidence then. Evidence for the plaintiffs.
Yes, Your Honor, the plaintiffs will call as their first witness, Bob Phillips. And while Mr. Phillips is coming to the stand, Your Honor, I'd like to pass out a witness notebook.
Yes, sir.
I may approach, Your Honor.
Yes, please.
If you would please raise your right hand. Place your left hand on the Bible. Do you solemnly swear that the testimony you're about to give this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Right. Let me just point out that I don't believe there's a microphone seated directly in front of, or placed directly in front of the witness, so there is one somewhere in the ceiling, so you should be able to be heard, but we'll make, if you're not, we'll make some arrangements to see that everyone in the courtroom can hear. Go ahead, Mr. Spees.
Good morning, Mr. Phillips. Would you state your name for the record, please?
Robert Darden Phillips.
And would you tell the court a little bit about your background?
Absolutely. I'm a North Carolina native, born here, raised in Charlotte, educated at UNC Chapel Hill. First, I guess I've had three distinct careers. First job was working as a reporter in the Triangle area. Secondly, I worked as a communications director for Lieutenant Governor Dennis Wicker, who was the Lieutenant Governor from 1993 to 2001, and have been at Common Cause as executive director for about the last 20 years.
And what are your duties as Common Cause executive director?
Essentially, I kind of lead our mission to carry out what is the mission of Common Cause. That includes education, educating the public on some of our goals, lobbying the North Carolina General Assembly, of course, and responsible for trying to raise the money to sustain our organization.
And would you distinguish Common Cause from Common Cause North Carolina for the court, please?
We are a state chapter. We work with North Carolina issues and, again, lobbying the North Carolina General Assembly. We work on a variety of issues here, lobbying and ethics, big money politics, voting rights, and, of course, redistricting reform.
And how many members does Common Cause have?
Nationally, over 500,000. Here in North Carolina, 25,000.
Do you have an exhibit notebook in front of you? Sorry, we didn't give you one. I may approach the witness, Your Honor.
Yes, please.
Mr. Phillips, I've put in front of you a notebook that contains some exhibits we will discuss today. Would you please turn to Exhibit 440, which is contained in this notebook? 644, I'm sorry.
Yes, sir. I have it.
And what is that?
That is a list of members broken out in the Senate districts.
And does that list the members of Common Cause who reside in these particular districts?
Those are the numbers of Common Cause members who do preside in those Senate districts.
Would you tell the court a little bit more about what the mission of Common Cause is?
Strengthening democracy. I mean, principally, what we try to do is we're advocates for more open, honest, and accountable government. A big part of our mission is just to increase the participation of citizens in our democracy.
Is redistricting reform a part of Common Cause's work?
Indeed, it is.
And could you explain to the court why that is?
There's nothing in our mind that's really more significant, consequential in a legislative session than redistricting. I mean, that really locks in for the next decade everything, including who gets elected and what the power share will be. Ultimately, what kind of laws and policies are going to be emphasized, and then what will not be, what will be ignored. How the public is going to be able to relate to the General Assembly, who are the leaders, and ultimately what laws will be enacted. All of that happens when those redistricting plans and laws are passed in that decade, and this is why we've always felt like this is something that we need to address.
And what type of reforms to the redistricting process have you advocated?
Something completely counter to what we do now. We think that the process should be open. We think that it should not be behind closed doors. We think, just as the judges made the great case when judicial redistricting was being heard in the legislature, judges wanted input. We want the public to have input. We want the public to have robust input in this process. And certainly, last but not least, removing politics out of the process, not looking at past election results, not looking at what the partisan affiliations are of people. That's the kind of reform measures we have advocated.
And let's talk about your efforts in the legislature to reform the process. Do these efforts go back to the early 2000s?
They do. For the last 20 years, yes, sir.
And Mr. Phillips, if you would turn to Exhibit 631 in your notebook, and I would ask you if that is a copy of Senate Bill 285 that was filed in the General Assembly on March 1, 2001.
Yes, sir.
And what was the title of that bill?
Independent Redistricting Commission.
And who were the sponsors of this bill?
Well, the primary sponsor was Senator Ham Horton of Forsyth County, who is deceased. Some of the other sponsors include Senator Phil Berger from Rockingham County and Senator Rucho of Mecklenburg County. These are the Republicans who were the leaders of their party in that time.
And what sort of reform did they seek? If you would turn with me to page 2 of your of that exhibit and look at subsection F, is it correct, Mr. Phillips, that the remedy they sought was a prohibition against considering partisan affiliation and voting data?
Yes, I mean that's the language. That is the language that really has been common in every reform bill, but that is true. And it's right there.
And did your efforts continue through the rest of that decade?
Yes, sir. It did. It did.
Would you turn with me to Exhibit 633? And let me ask you if Exhibit 633 is a copy of Senate Bill 25, filed on February 3, 2009 in the General Assembly.
Yes.
And who were the sponsors of that bill?
This was, the primary sponsor was Senator Brunstetter, who had replaced Senator Horton, also of Forsyth County. Senator Horton, as I mentioned, had passed away, but Senator Berger, one of the, again, major sponsors or the sponsors of that bill, Senator Apodaca, again, most of the Republican senators of that time.
And what was the title of this bill?
The Horton Independent Redistricting Commission.
And who was Horton?
Ham Horton was a state senator from Forsyth County. He was the champion of redistricting reform, really the top champion. Common Cause actually honored him at one of our annual banquets. And he passed away sometime, I think, 2006 or 2007.
And is he the lawyer who brought one person, one vote to North Carolina?
My understanding is he is, yes, sir.
And what kind of remedy for partisan gerrymandering was sought by this particular bill creating the Horton Commission? Would you turn to page 3 of this exhibit, Mr. Phillips?
It mimics the same language. Again, the key piece being that there would not be any consideration of past election data, the political affiliation of voters. In our mind, this is removing politics from the process.
Okay. And would you look, please, Mr. Phillips, at Exhibit 634 and tell me if that's a companion bill to this Senate bill that was filed in the House on February 23, 2009.
Yes, sir, it is.
And who were the sponsors of this bill?
Well, a couple of them that I remember well, Ruth Samuelson from Mecklenburg County and Skip Stam, Wake County, were primary sponsors, but also sponsoring of those bills, Representative David Lewis and Representative Tim Moore.
And the remedy for gerrymandering run amok in that instance was the same thing, the elimination of political data in drawing districts?
Yes, sir, same language.
And if you would turn back with me, please, Mr. Phillips, to Exhibit 632, I would ask you whether that is another bill introduced in the legislature on April 7, 2011, and entitled, a bill to be entitled an act to establish a nonpartisan redistricting process.
Yes, sir.
And is this one of the bills you advocated for?
Yes, sir.
And who were the sponsors of that bill?
Primary sponsors included Representative Lewis and Representative Rick Glazier. What's significant about this bill is it had bipartisan support. It was actually a bill that was heard in committee. The first time in my 20 years we had actually had a redistricting reform bill that was heard in a legislative committee, and it as is indicated here, it actually passed in the State House.
And if you would turn with me to page 4 of Exhibit 632, I would ask you once again if the cure for gerrymandering run amok was the elimination of political affiliation and political data in drawing maps.
Yes, sir.
Now, let's talk a little bit about the harm that you believe the gerrymandering process in North Carolina has caused to Common Cause and its members. Could you discuss that with the court, please?
Absolutely. To us, the centerpiece of what the harm really connects back to is, again, this use of political data. And the bills that we worked with Republicans, Representative Lewis, Representative Moore, Senator Berger at that time, was to, again, remove politics from the process. One of our central missions at Common Cause is to help citizens understand that they do have an obligation and that they can hold their electeds accountable. How do you do that when so many, 90% of our legislative seats are preordained, either non-competitive or run uncontested? Accountability is a very hard thing for citizens to really feel like they have an opportunity. People who are in, the representatives who are in these districts also, they really don't have an incentive or an obligation to try to serve all of the members, particularly those people who are in the parties that are not theirs. We see that.
Excuse me, Mr. Phillips, does Are you also concerned that gerrymandering discourages citizen participation?
Absolutely, it does. When you have, again, districts and the overwhelming majority are non-competitive and it's preordained. We already know the filing date, basically who's going to win. It's hard to get citizens, voters to participate, to think that their vote really matters.
And do you have concerns that voters are penalized for expressing their opinions at the polls?
They are. Their preferences are basically how they are divided and put into districts. And that's just unfair. It shouldn't be that you're placed in districts based on your political preferences.
And is Common Cause concerned that the present form of redistricting in North Carolina treats voters on unequal terms?
It does, and this is where we think it's a violation of the Free Elections Clause, because you have the classic methods of gerrymandering is packing and cracking, and you're packing voters into safe districts, or you're cracking them and dispersing them out, and it's nullifying the power of the vote. It's not really allowing that equal vote that we are all supposed to have.
Let's turn, Mr. Phillips, to the 2017 redistricting process. I believe the record here will establish that the first meeting of the legislature to resolve the problems with the old map was a joint redistricting committee on July 26. Were you present at that meeting?
Yes, sir, I was.
And did the legislature allow public comments at that meeting?
They did.
And did you speak at that meeting?
I did speak at some of the meetings. I think I did.
Okay. And if you would turn with me, Mr. Phillips, to Exhibit 602 in the front of you. Is that the transcript of the August 4 meeting of the Joint Redistricting Committee?
Yes, sir.
And would you turn with me to page 58 of that document?
Yes, sir. This is where I spoke.
Yeah, and did you speak at that public
Yes,
hearing?
sir. Yes, sir.
Did other people speak at that public hearing?
They did. It was a long list of folks. There were a lot of people.
Do you recall anyone advocating continuation of the present process?
It might have been one person. Dallas Woodhouse, I believe, was there and spoke for that.
And if you would turn with me to Exhibit 607, please, Mr. Phillips. Is 607 a part of the transcript of a public hearing held by the General Assembly in Raleigh on August 22, 2017?
Yes, sir.
And did you speak at that meeting?
Yes, sir, I did.
And did a number of other citizens speak at that meeting?
That was a public hearing that went well late into the night. Yes, sir. A lot of people.
Do you recall any person appearing at that public hearing advocating for the continuation of the present system?
Excuse me, I'm sorry. Might have been the same individual, one person that I recall.
Do you know who Tom Hoffler is?
Yes, sir.
Did Mr. Hoffler come speak at these public hearings?
No, sir.
Mr. Phillips, would you tell the court why Common Cause is participating in this lawsuit?
We feel that there has just been no opportunity to pass meaningful redistricting reform in the General Assembly. I've been at this for 20 years. I work with Representative Lewis, Representative Moore, Senator Berger, certainly Senator Wharton, all these years, and we never were able, we thought we were close to make a reference to Charlie Brown and Lucy. Charlie Brown tries to kick the football, Lucy yanks it away. I kind of felt like that was how the legislature was yanking away the opportunity for us to pass redistricting reform. So we felt like litigation was a remedy to actually get something done.
Did you believe, based on all your many years' experience pursuing this issue, that the legislature would never be able to bring itself to resolve the problem?
Absolutely. Just the aspect of wanting to hang on to the power And I've seen it on both sides of the aisle, obviously, but absolutely that's true. That we've had a majority of folks in both parties agree to redistricting reform, but we can never get them at the same time. If one party has the power, they don't want to do it.
And Mr. Phillips, has Common Cause been involved in other projects intended to help citizens and the legislature understands that there is a solution?
We have. I mean, again, one of our missions is to educate the public, and we try to be as creative as we can, and we have done several things to help raise awareness of this problem.
And was one of those a joint project with Duke University School of Public Policy?
It was. We actually enlisted the help of former appellate court justices, including Justice Henry Fry and Justice Rhoda Billings, and basically gave them the criteria that we liked, particularly taking politics out of the process, and said, here, draw us a congressional map, and that's what we did.
And did you ask them to draw maps using just traditional criteria and ask them not to use political data?
That's correct.
That was the congressional map, I believe you.
Yes, sir, it was.
Did you have a similar project involving the legislative map?
We did. We had such success with that. We had a lot of attention. So we thought, why not do the same thing? And we selected two 3L Campbell law students here, one Republican, one Democrat, gave them, again, the criteria and asked them to draw legislative maps.
And what process did those students follow in drawing those maps?
The same. No look at use of political data. What would mimic in those bills, all those reform bills that we've advocated for all those years.
Did Common Cause present either the congressional map or the legislative map to the legislature for consideration by the legislature?
No, we never did.
And why not?
That wasn't the point. The point was to really raise the awareness of what a impartial process can do. So we put it on our website, we had some press attention, but we never formally handed a map to anyone and said, this is the map, these are the maps that should be used.
Were the Campbell maps, in fact, introduced in the General Assembly?
Yes, sir, they were.
Do you remember when that happened?
July 26th at that first meeting.
And were you surprised?
I was very surprised, yes, sir.
Okay. Why were you surprised?
I'd never had any contact with the legislature. They had never told me that they were going to do this. It is part of the public record, but we were sitting there and then this handout was presented as the Common Cause map. So I did not have any warning that they were going to do that. So yes, very surprised.
And did you later learn that the legislature had a political analysis done of your maps?
Yes, sir.
And would you turn with me, Mr. Lewis, to Exhibit 757, which I believe is the last tab in your notebook. And I would ask you if you recognize this as an email change of correspondence between Brent Woodcox and Raleigh Myers.
I see that it is, yes, sir.
And who is Brent Woodcox?
He's an attorney, a staff for the state Senate leadership.
And who is Raleigh Myers?
He is a state employee who works with the where the state computer is, and we actually worked with him with the Campbell experiment. The state computer has the Maptitude software, and he is someone who works there and helps the public and also lawmakers with using that software and that computer.
And was Mr. Woodcox, in effect, asking Mr. Myers to get the stat pack information about your map to the legislature?
Yes, sir. That's what the request is.
And are you familiar with the term stat pack in the redistricting context?
Yes, sir.
And every map has a stat pack, I believe.
Right.
And every map to this point has had a bunch of political analysis in it, hasn't it?
It has.
And did this one have that political analysis in it?
Not by us, but obviously we created these maps on the state computer using the Maptitude software. We again wanted to be as true to letting these Campbell Law students do what the lawmakers do. So the stat packs were created.
Did you later learn the use that Mr. Hoffler had made of your Campbell Law student maps?
Only recently, yes, sir.
And what use did you find out he had made of your maps?
That he had looked at the Campbell maps, again, the maps that the two students created, and essentially...
John, I'm going to object. This sounds like hearsay, how he would have known what Dr. Hoffler did or didn't do, because Dr. Hoffler's been dead for some time now. Mr. Spees.
Mr. Phillips, did you at some point learn of the use that had been made of your maps in political terms?
I learned that the maps had been essentially analyzed and graded for political performance, i.e. which districts would perform best for Republican performance.
Your Honor, objection again. We don't know who he's talking about did this analysis. I assume this is a backdoor way of saying Dr. Hoffler did it, but it's clearly hearsay.
And Mr. Phillips, have you seen documents in which this?
We need to rule on the objection.
I'm sorry, Your Honor.
Or unless you're withdrawing the question
No.
and restating it, then we'll need to rule on it.
No, I'm sorry.
All right, then, as a three-judge panel, we'll need to develop a process for ruling on the objection so that we at least come up with a majority decision among the three of us. So we'll confer for a moment here at the bench. All right. The objection is sustained, but you may rephrase the question.
Mr. Phillips, did you ever have an opportunity to compare the Campbell student maps with the enacted map to see if there were any overlap in those maps?
We never did that.
Did you later learn that there was some overlap?
I did learn that, yes, sir.
And how did you learn that?
I learned it from counsel that had occurred, yes.
Did you have an opportunity to look at an analysis that had looked at that issue?
Yes.
Okay. Were you, do you know whether or not the districts in your maps that match the enacted map have a similar political performance?
Well, I do understand that there were 4 districts in the enacted maps that were identical to what the Campbell Law students had actually drawn, yes, sir.
And did you learn that the maps in your map that are duplicated in the enacted map had a very favorable Republican performance?
Right, that's my understanding, yes, sir.
And what was your reaction to that?
Well, I was surprised but also disappointed that an exercise we had done to really show what an impartial process could look like, and the map was a byproduct of that, would then somehow cravenly be used as to making a point of partisan politics in play.
Your Honor, just like that answer, used by who and when and how, it's all speculation and hearsay.
Your Honor, I would, those will conclude my questions for Mr. Phillips at this point, and I don't know how you want to handle moving the admission of exhibits.
Right.
I could move them now or wait until the end of his testimony, whatever the court might prefer.
Right. So we have Again, I know we have exhibit lists, we have stated objections. Of course, there is a presumption that exhibits and testimony that's received in a bench trial that the court will disregard inadmissible evidence and assign such weight and relevancy to it as is fit. So there is that presumption that operates. There does need to be a formal motion to admit the exhibits you intend to move in. We're happy to hear objections to those exhibits. What I would say, just as Mr. Strack has been doing, if there are specific exhibits or testimony that's coming in that there is objection to us hearing, that they be made at the time that you start referring to the exhibit. I know they've been published and we've received copies, but we do need at some point a formal motion and any formal objections that are to be made.
Your Honor, since I might have some redirect, why don't I do that at the conclusion of this? Thank you.
Cross-examination, starting with the legislative defendants. Again, I'll also note a little bit unusual for North Carolina courtrooms. Standing while asking questions is not generally done in our courtroom, but I think it will work just fine for these proceedings so that everyone can be heard and seen.
Thank you, and we may, through the 2 weeks, have some lawyers who would prefer to sit, but we can address that at that time.
Absolutely.
That's all right. Okay. Good morning, Mr. Phillips.
Good morning.
Good to see you again.
Good to see you.
Now, Mr. Phillips, you referenced a number of bills that Common Cause supported throughout the years to create independent redistricting commissions in your direct examination. Is that correct?
Yes, sir.
And isn't it true that none of those bills passed the legislature?
None of the bills passed the legislature. That's correct.
All right, and these were bills that failed the legislative process when the legislature was controlled by Democrats at some time, correct?
That's correct. The first decade, the legislature controlled by Democrats, none of the bills, passed.
All right, and these bills have also failed the legislative process when it was controlled by Republicans, correct?
Different versions of those bills, yes, sir. That's correct.
All right. So you've not been able to accomplish this goal through the legislative process yet, have you?
We haven't. We thought we were getting close in 2011, but we have not accomplished that.
All right. You recall we met, the last time we met was in your deposition. You recall that?
Yes, sir.
And is it true that you were the person that Common Cause designated to speak for the organization?
Yes, sir. Generally, I guess that's correct.
All right. And do you recall that you were not able to say at that time what actual districts Common Cause was challenging?
Right. The districts that we were challenging were really council looking at that. We have always, as I had said in deposition, and have been consistent, it's always been to us a challenge of the process.
All right. So let me make sure I understand your testimony. You're saying that Common Cause did not decide what districts to challenge in this case?
Well, we challenge the districts, we challenge the maps. We feel like they are a violation of the Constitution. Free elections, equal protection, free speech. So yes, to be clear and precise, we do challenge the districts and we do challenge the maps. In terms of how it broke down, I wasn't the one solely making that decision.
All right. But it is true that plaintiff Common Cause did not make the decision about which specific districts to challenge in this case. Is that correct?
We were, I mean, again, I guess it's semantics. I did not make the final decisions on this. I was aware, but it would not be accurate to say that Common Cause made the sole decision on the districts to challenge that are being challenged.
All right. Occasionally this morning we're going to take a look back at that deposition.
Okay.
You recall being at that deposition?
Yes, sir, I do.
You recall you were under oath at that time?
Yes, sir, I do.
All right. I asked our folks to pull up your deposition transcript, and it should appear on your screen, I hope. And I hope the judges will be able to see it. And, Your Honors, we'll give you all a copy. Okay, great. Thank you, Your Honor. Mr. Phillips, we're going to turn this deposition transcript to page 40. And when it comes up on your screen, I'm going to start with line 14, if you can see it. And I'm going to read the question, and I'm going to ask you to read the answer, if that's okay.
Okay.
All right. So the question is, how did Common Cause decide which districts to highlight in the complaint? Your answer.
That was not something at Common Cause that I was involved in, or I didn't have in terms of the specific districts. That was not something I was involved in.
All right. Who at Common Cause was involved in that?
No one.
No one? Answer.
We are a plaintiff, but we didn't make a decision about the districts in terms of the specifics.
Okay. Now, you've mentioned today, and I believe you mentioned in the decision, that you are challenging the map, correct? Is that correct?
Yes, sir.
And are you challenging every single district in the map?
We are challenging the districts that have been outlined in our complaint as well as the map. Yes, sir.
All right. And when you mean the map,
Or maps.
Okay, when you say the maps, what you really mean is you're challenging the process by which the map was enacted. Isn't that right?
That's the central part of our challenge, yes, the process. And that the maps are, as I know it's not up, but the deposition we talked about, that the bad process creates unfair maps.
All right, so you believe a bad process creates an unconstitutional map. Is that correct?
I do. Yes, sir, I do.
All right. And again, we talked about the 2011 plans at your deposition. In fact, you don't believe that the 2011 plans were unfair from a partisan perspective, correct?
I think that any map that is drawn the way we do it in North Carolina is unfair.
All right. And do you think that any map drawn the way we do it in North Carolina is also therefore unconstitutional?
Yes, because I think it's violating our state constitution. Again, equal protection, free speech, and free elections.
All right. Let's pull up Legislative Defendants Exhibit 240. Can we go ahead and give each other? Your Honor, we're going to provide you a copy. Mr. Phillips, do you recognize Exhibit 240 as the simulation map that Common Cause produced for the State House as part of the project you described when talking to Mr. Spees?
The only thing I would differ is just, again, how you kind of present this. This is the map that the two Campbell Law students created for us as a demonstration of how impartial redistricting can work. So yes, I recognize the map in that context.
All right. And you agree, though, that this was a project that was initiated by Common Cause, correct?
Yes, sir. Indeed it is.
All right. I want you to look at districts 25 and 7 on this map. And Do you see those two districts in Franklin and Nash County?
Yes, I think I know my North Carolina geography, but it did take a little time to find it. I do. There it is.
All right. And these two districts in the your house simulation map are essentially identical to the districts adopted by the legislature in this county grouping. Is that correct?
Yes, sir. That's correct.
All right. And isn't it true that Common Cause is challenging these two districts in the House plan?
Yes, sir, we are.
And you are challenging them even though they are identical to your simulation, correct?
Yes, sir.
But now, are the two districts in this county grouping that are identical to the districts in your simulation, are your simulated districts partisan gerrymanders in your view?
Well, again, the point of the exercise was to allow two young people who had never done this, but giving them the criteria to see what they would produce. Our focus was not exactly on the maps. The difference between what the students did and what the map maker did for the General Assembly was, holistically, it was all about rigging the map and maps. This was not what the students were doing.
All right, so you don't believe that what the students did is a gerrymander because they used a different process, is that correct?
Well, their intent was not to gerrymander on a partisan basis. They were purely trying to do those things we want: compact, contiguity, equal population, respect VRA, but take politics out of the process. To pick a couple of districts that are identical to, again, the enacted maps, my own opinion is not that significant. You have 168 or 166 that are different.
All right, so even though these two districts are identical, in the view of Common Cause, what makes one set in your maps okay, but one set in the legislative maps illegal is who drew them. Is that correct?
Well, it's the process, and again, I guess I would just say that in the Duke project and the Campbell project, we never did say to anyone, these are the perfect maps. These are the maps that the legislature should consider. It was all to us about showing the impartial process and the exercise of that, not the byproduct of the maps.
All right. In fact, Mr. Phillips, Common Cause believes that where the party in power draws the map, that those maps are therefore going to be unfair. Is that correct?
If the party in power is using the rules that we have, and that is that political data, and it's all about looking at past elections, then we come down on that belief that it's likely to have problems. Historically, we've seen that again when Democrats were doing it, and certainly as technology has increased, and the current majority party has certainly engaged in that in our view as well.
All right, and let's look again at your deposition. We're going to look specifically at page 27, if we can put that on the screen, please. All right, and if we'll start with line 10, Mr. Phillips, and I'll read the question, and if you'll read the answer to the court, please. And with regard to the 2011 plans, in what way was the outcome not fair? And what was your answer?
I believe that the outcome was not fair because, again, the process was allowing the party in power to draw the maps to their favor. That's whether it's the Democrats drawing the map when they're in power or the Republicans who have been able to have that right since 2010. Anytime that a map is produced and you have that process allowing a party in power to draw the map, we would feel that it's not going to be fair.
Right, and Mr. Phillips, isn't it the case that Common Cause filed this lawsuit to try and force the legislature to enact redistricting in form that Common Cause would like?
It's the case that we want a new process, and we have failed so many times in the past 2 decades, and this is where we feel like the remedy lies. Yes, sir.
So is the answer yes, that Common Cause filed this lawsuit to try and force the legislature to enact redistricting reform satisfactory to Common Cause?
Well, when you say satisfactory to Common Cause and force, let me think about this question a bit. I mean, my thought is that it's to create a better process than we have. And it is for the purposes of eliminating and removing this flawed process we now have been engaged in for forever.
Right, and so let me repeat the question. Isn't it
Yeah.
true that Common Cause filed this lawsuit to try and force the legislature to enact, let's say, in your words, a better process for redistricting? Is that true?
We agree that the legislature has a role in this and that they must also pass some kind of redistricting reform. If we are successful in this litigation, then our hope is we would have some new standards and rules regarding no longer use of politics in the process.
All right, I'm going to show you a copy of a press release from Common Cause dated November 13, 2018. And Your Honors, for the record, we'll identify this as Impeachment Exhibit 1. And if we could hand the judges a few copies. And if, Forrest, if you could bring up the press release of November 13, 2018. Mr. Phillips, if you'll turn to page 2 of this press release. Well, let me ask you first, are you familiar with this press release?
Yes, sir.
And did you assist in the drafting of the press release?
I know I looked it over before it was finalized. Yes, sir.
All right. And this is a press release from Common Cause, North Carolina, correct?
Yes, sir. We're a part of this press release. Yes, sir.
Okay, you are a part of the press release. And you are the top official at Common Cause, North
Yes,
Carolina,
yes,
correct?
sir.
All right. Well, let's look at page 2. The first full paragraph, there's a statement that reads, and again, this is November 13, 2018. Is this the day that the lawsuit in this matter was filed?
Yes, sir.
All right. So on November 13, 2018, the day that this lawsuit was filed, you commented, quote, because lawmakers stubbornly refused to consider passing redistricting reform, we're left with no choice but to litigate. Did I read that correctly?
Yes, sir.
And is that your statement?
Yes, sir.
All right. Now, this lawsuit, the maps that are at issue in this lawsuit most recently were enacted in 2017, correct?
Yes, sir.
And Common Cause did not bring a lawsuit right after the map were passed, correct?
No, sir, we did not.
And in fact, the lawsuit was brought after the November, the results of the November 2018 elections were known, correct?
That's correct.
So isn't it the case that Common Cause of North Carolina was waiting to see how the November 2018 elections would pan out before it decided whether it would file this lawsuit?
No, sir. I mean, we were, as you know, engaged in another litigation at a federal court, Common Cause v. Rucho, and this was certainly something we were looking at and considering, but there was not a specific decision to state, let's wait for the election results, and then we'll see where things are and file the litigation.
All right. But it's the truth, isn't it, that you filed the lawsuit in 2018 rather than 2017 because you were waiting to see if the legislature would enact the reform that you wanted?
That's a part of it. Again, we had a reform bill filed, and certainly we never try to give up hope. So yes, we were continuing to advocate for redistricting reform.
All right, and the reason your Common Cause in North Carolina is continuing this lawsuit is to obtain a Citizens Redistricting Commission, isn't that true?
We think that would be one of the paths that would be better than what we have now. I mean, I guess there are a half dozen redistricting reform proposals that are pending right now. None have been heard in any kind of committee. That's one of the options, yes, sir.
All right, and you've recently commented that if the legislature would pass such a bill, Common Cause would consider dropping this lawsuit, didn't you?
We did. We were challenged by Representative David Lewis, again, who I used to work with very closely on this issue. And we said, pass the gold standard redistricting reform model, and then we'll consider dropping the lawsuit. And that gold standard is a couple of the bills embody what we talk about.
All right, let me shift gears a little bit, Mr. Phillips, if that's okay. You understand, don't you, that Common Cause is a lead plaintiff in this case, correct?
Yes, sir.
That is, the Common Cause name leads the caption of the lawsuit, correct?
Yes, sir.
As the lead plaintiff in this case, isn't it true that Common Cause does not have a partisan gerrymandering that it intends to offer the court?
Does not have, will you rephrase that, or let me make sure I understand what you're asking me?
Absolutely. Isn't it true that Common Cause does not have a partisan gerrymandering standard that it intends to offer the court?
We don't necessarily have a partisan gerrymandering standard. Again, being consistent, and I know I'm repeating myself, it's all about a process of taking politics out of the whole redistricting plan and process, and that's where our focus and our emphasis is.
All right, and when Common Cause speaks about, quote, partisan gerrymandering, what Common Cause is referring to is the gap between what the vote share statewide might be and the proportion of seats that one party has. Isn't that what Common Cause's view of this is?
You know, that's a fact to look at. I think another fact is that 90% of the 170 North Carolina General Assembly seats, as I've mentioned before, are virtually non-competitive, either uncontested completely or the candidate who wins with a comfortable double-digit margin. That's the crux of the matter when you are gaming, rigging, drawing districts in such a manner that there is no competition with the overwhelming majority of the 170 seats of our legislature. That's the piece that we're really looking at.
And you're talking about uncontested races, correct?
Races that are completely uncontested or for all practical purposes are non-competitive. Again, you add those two numbers up, and historically, when Democrats were in charge as well, 90% are either uncontested or they're winning by a comfortable double-digit margin.
Well, let me ask you this then. This map was passed in 2017 and used for the first time in 2018, correct?
Yes, sir.
Isn't it true, and aren't you aware, that the Democratic Party had a candidate to run in every single legislative district this time?
That was I think the first time since I've been at Common Cause when you literally had perhaps at least two people on the ballot at the same time in every district, or practically every district.
And
yes,
that was
sir.
the first time in a generation that happened, and the first time it happened was under the 2017 plan. Is that correct?
It did, yes, sir. It did. I don't know that that was necessarily the reason. I think it has a lot to do with the 2018 election, the voter enthusiasm, just everything building up to that election cycle.
Okay. Let me shift gears again. I want to ask you about some Voting Rights Act analysis that we've discussed in the past.
Okay.
So you had two students who drafted the districts in these maps, correct?
Yes, sir.
And the students did have some help occasionally, isn't that right?
They had help with regards to the mechanics of the Maptitude software. That was mainly their help, yes. I mean, mainly the help we provided, yes.
And who Common Cause primarily provided that help?
The two folks, a friend of Common Cause, Bill Gilkison, who's a former legislative staffer, and then Brent Lawrence, who is one of my colleagues on staff at Common Cause, North Carolina.
All right. In drawing these districts, did you permit the students to use race data in the drawing of the districts?
We didn't, not the first round. We looked at it afterwards, which my understanding is permitted by the law, but that's how we did that.
Okay, so just to be clear, they did not use racial data in the drawing of the districts, but they did look at the racial statistics on the back end once the districts were drawn.
We did want to see that we were complying with the Voting Rights Act, which is obviously constitutionally mandated, and so that is, and again, I was not always with them, but I know that we looked at it on the back end. I don't know that we really had it on the front end. My understanding and recollection, rather, is that we looked at it more on the back end.
Okay. And Mr. Gilkison assisted with that analysis, is that correct?
Yes, sir.
And is it true, at some point you submitted these maps to the federal court in the Covington case, is that correct?
Again, what we did is this is when the Covington case was relevant and live in Greensboro, and we wrote a letter as they were trying to determine what were they going to do, what was the order going to be to the legislature. And the crux of what we submitted, and it was in a letter, which I believe you have, was adopt impartial criteria. Along with that, we made note of this Campbell exercise and included the map.
All right, and when you submitted those maps to the court, you represented to the court that the simulated districts comply with the VRA, didn't you?
We did.
All right, let's pull up LDTX 241. Mr. Phillips, do you recognize Exhibit 241 as the letter that you wrote to the federal panel in the Covington case?
Yes, sir, the aforementioned letter. Yes, sir, that's it.
All right, and you knew that that federal panel would soon be overseeing a process of redrawing the districts, correct?
Correct.
And when you submitted this letter, you also references attaching the maps. Did you also attach the maps?
Yes, sir.
Okay. And in the third paragraph from the bottom, in the last sentence, you wrote, the process works and resulted in districts that were more compact, met the requirements of the Voting Rights Act, and resulted in more competitive districts. Did you write that?
Yes, sir.
And you were representing there that the simulated districts met the requirements of the Voting Rights Act?
Yes, sir.
And was that a true statement then and a true statement now?
At that time, we felt like we had satisfied the Voting Rights Act, so I would say yes to both your then and now.
All right. Let's pull up Legislative Defendants Exhibit 242. And Mr. Phillips, Alyssa, Your Honor, may we approach the witness with a copy since it's a long document? Phillips, we're going to hand you a hard copy of this
Okay.
because it's numerous pages. Now, Mr. Phillips, when these simulated maps were drawn, you testified that they were drawn on the General Assembly's computers at the legislative building, correct?
Yes, sir, that's correct.
And that was done so that Common Cause could generate the statistical information that the General Assembly generates when it draws a map?
We wanted to use the state computer with the Maptitude software because the software we had been using, something called Dave's Redistricting, which is a very credible software, but it doesn't allow you to drill down and be as precise with the equal population standard as Maptitude. So that was a primary reason that we did that.
All right. And when the statistical information is generated for a map that's being drawn, it's generally referred to as a stat pack, is that correct?
Yes, sir.
And does this appear to be the stat pack for the House and Senate simulated maps that were done by the law students?
Yes, sir. I mean, I'm going to say yes. I mean,
You'll see that it was also marked, if you look at the first page, it was marked as Exhibit 19 in your deposition.
Mm-hmm.
Do you recall us looking at that?
I do, yes.
And you recall us agreeing?
Yes,
that
sir. Yes, sir. I'm not casting any doubt about that, yes.
All right, good, thank you. Let's pull up LDTX 230.
Before we get into another exhibit, we're going to go ahead and take a
Yes.
15-minute recess. And we'll go to about 1 o'clock and we'll break for lunch at that time. But so we'll come back and have about a 45-minute session. So Bailiff will be in recess.
15 minutes.
got to set aside 2 weeks, but
I'm thinking by Wednesday we may be able to answer that question. I think it's going to be hard. We're going to, once we get a feel for the flow,
right.
I think we'll be able to give you a better idea, at least from my perspective. I don't know if Eddie's got a better crystal ball.
Gotcha. Okay. Well, I was just wondering if I should plan for 2 weeks or 3 weeks. Or...
Definitely, they won't let us go 3, so I don't think you need to worry about that.
So 2 weeks is
Yeah, 2 weeks is max. Yeah.
Further questions, Mr. Strack?
Yes, Your Honor. Thank you. I'm going to momentarily go back to Exhibit 241, Mr. Phillips, which I believe was the letter that you wrote to the federal court. Do you recall us talking about that?
Yes, sir.
Do you have it on your screen yet?
Not yet, but
241.
there it is.
All right, I just want to clarify something. This letter was written by you to the federal court, correct?
Yes, sir. We wrote the letter and then presented it or sent it to them. Yes, sir. That's correct.
All right, and that's your signature at the bottom of the letter?
Yes, sir. It is.
And you're writing it in your capacity as Executive Director of Common Cause North Carolina, is that right?
Correct.
And you state in the third to last paragraph that at Common Cause North Carolina, we have hosted 2 simulations conducted by well-respected bipartisan entities where nonpartisan criteria were followed in drawing congressional and legislative districts. You see that?
Yes, sir.
All right, you didn't mention in that paragraph that 2 law students drafted the map, did you?
No.
And you enclosed copies of the maps for the court's use, correct?
Correct.
So these are Common Cause maps, isn't that correct?
Well, we hosted the project, and I guess in that sense, ownership of it. But again, when you say Common Cause maps, we did not present the maps in the context of the legislature and alerting or asking the court to have the legislature adopt these maps. And again, no one on my staff created the maps. We oversaw this process of these 2 Campbell Law students doing that.
Correct. You didn't mention that process in this letter, did you?
No, I did not.
And instead, you represented these maps were maps from Common Cause North Carolina, isn't that correct?
I say we've hosted 2 simulations conducted by well-respected bipartisan entities. So the well-respected bipartisan entities would be, in the Duke case, the appellate judges, retired appellate judges, justices, and then the 2 young people that we had at the 2 Campbell Law students. I think I can say they're respected bipartisan entities.
And Common Cause North Carolina was adopting these maps for purposes of submitting them to the federal court at least, correct?
No, sir. We took advantage. We're opportunistic. We had this experiment, this simulation completed in March, and didn't do anything with it, actually. I mean, we had it, but we didn't publicize it until June 29th. And again, it was taking advantage of the fact that the Covington Court was about to issue some kind of guidance to the North Carolina General Assembly regarding a new map.
All right, let's look at Exhibit 230. Mr. Phillips, we've already discussed that once the districts were drawn, Common Cause did an analysis of the VRA issues, correct?
Yes, sir.
And isn't it right that this document, Exhibit 230, constitutes the results of that analysis?
Yes, sir.
And this was an analysis conducted by the staff at Common Cause and Mr. Gilkison, correct?
It's probably, well, yes, correct. Yes, sir.
All right. On a different topic, Mr. Phillips, you have acknowledged, I believe in this case, that the entity paying the legal fees of Common Cause is called the National Redistricting Foundation. Is that right?
Yes, sir.
And isn't it true that the National Redistricting Foundation is associated with a national partisan entity?
There is a connection, I believe, to former Attorney General Eric Holder. I don't know what exactly the relationship when you say a partisan entity is. I think one's a C3 and one's a C4, I believe, in this overall what this organization is.
All right. Isn't it true that the National Redistricting Foundation is a 501c3 affiliate of the National Democratic Redistricting Committee?
I believe that's correct. If the latter you just spoke to is the C4, that might be correct. Yes, sir.
All right. Are you able to say that it surely is correct?
Yes, sir.
Okay.
Okay. Sorry.
Thank you, Laura. That's all I have for now.
Defendants, intervening defendants, cross-examination of this witness. All right. State. All right, very good. Redirect.
A few questions, Your Honor, thank you. Mr. Phillips, you've been at this a number of years. Is it your view as Director of Common Cause that the legislature is never going to be able to resolve the redistricting problem?
As much as I hate to admit it, I would say yes.
Okay. And Mr. Phillips, you're not a lawyer.
No.
You're a plaintiff in a lawsuit.
Correct.
And you are well aware that your lawyers are advocating that these plans violate specific legal standards. Is that correct?
That's correct. In our state constitution, yes, sir.
And they're right in the state constitution.
Correct.
And they're in the decision by the North Carolina Supreme Court in Stevenson versus Bartlett, correct?
Correct.
And in other decisions by the North Carolina courts.
Yes, sir.
And you're not here asking the court to turn over the redistricting process to a redistricting commission, are you?
No, that's not what the lawsuit and the relief we are seeking is actually asking.
What you're asking is that the constitutional rights of your members and the citizens of North Carolina be vindicated, correct?
Correct.
And how that is vindicated is for the courts.
Yes.
Your Honor, I believe that would conclude my redirect, and at this point, I would move the admission.
All right. Any objection to the so that, I believe that would be each of the documents that are contained in the notebook?
Yes, Your Honor, and they are exhibits 644, 631, 633, 634, 632, 602, 607, and 757.
All right. Any objection to the admission of those exhibits?
Your Honor, so we have no objection to those exhibits, but I have an observation or a recommendation.
Yes,
a thought. We use several exhibits, obviously. The parties, with respect to exhibits, the parties have already exchanged objections, et cetera. One thing we could do is reserve those objections until the parties see how the evidence comes in and brief those later, rather than burdening the court with the necessity of doing it witness by witness or document by document. We would have no problem doing it that way, but we assume that if the court does not do it that way, we would wait until our case to move our exhibits in. So we're obviously happy to do it however the court wants us to do, but that is one alternative way of doing it if the plaintiffs are okay with it and if the court agrees.
We're for the most efficient way, Your Honor, and maybe after each witness, I have a problem keeping up with the exhibits at some point. But whatever the court pleases, we would be pleased with.
We are happy to minimize the number of objections that have to be ruled on from the bench. That creates logistical problems. So we're happy to, if the parties agree, to receive items into evidence provisionally, subject to the parties having an opportunity to be heard either in writing or orally as to any objections. We can do that as we move forward. If the plaintiffs consent to the introduction and receipt of evidence during the plaintiff's case, then we can certainly honor that compromise or stipulation, but that would be up to the plaintiffs if they wish to allow you to actually introduce exhibits during the plaintiff's case in chief. But we're happy to receive them at any point in your case in chief as well, Mr. Stroud.
So we would consent to reserving objections on documents, on exhibits until after trial to be briefed, but continue to do objections for testimony as we have been this morning if the plaintiffs agree and the other parties.
Just 1 minute, Your Honor.
Yes.
Your Honors, this could be a problem in connection with some of the expert reports to which there are numerous objections. And it seems to me that it would be actually easier, especially with that kind of document, that those objections be dealt with as the evidence is presented and ruled on. If the defendants would withdraw their objections to those documents, maybe we could proceed another way.
Well, I wanted to make the suggestion to be efficient for the court, not to waive any objections. So we'll be happy to move our documents in, Your Honor, during our case, and then the plaintiffs can move their documents in as they see fit.
I think that may be the way to do it. It seems to me that if we receive evidence and then at the end of the trial have to consider objections that might exclude significant portions, then it's probably better that we deal with that at the time that evidence is being received. So I think that the way we'll need to do it is either, as Mr. Speece is doing right now, introducing a group of exhibits that have been published and discussed by witnesses. You can state any objection you have to those. If there are objections that need to be made at the time that they are shown to a witness or prior to publication or prior to distribution to the court, then of course you can do that, and that applies both to exhibits and testimony.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
Your Honor, the plaintiffs would call as their next witness Senator Dan Blue.
So let's, for the record purposes, let's find out what we're doing with the exhibits that were moved into evidence. Was there objection? I believe you said there was no objection.
There was no objection.
All right, and Mr. Branch?
No objection.
For the state? All right, so then those exhibits, namely the exhibits that were contained in the notebook and just recited by Mr. Speece, are allowed into evidence.
Your Honor, while Senator Blue is coming to the stand, if I may, her witness notebook for this witness.
Yes, please.
Please remain standing. Place your left hand on the Bible and raise your right. Do you solemnly swear that the testimony you're about to give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, so help me God.
Thank you. You may be seated.
Your Honor, if I may approach the witness and give him the witness notebook.
Yes, sir.
Good morning, Your Honor. Good morning. Okay, I'll try that. Thank you.
Thank you, Your Honor. Good morning, Senator. Would you state your name for the record, please?
Good afternoon. I'm Daniel Blue.
And would you tell the judges about your background?
I have practiced law here in Raleigh since 1973. Prior to that, I was a law student at Duke. And prior to that, an undergraduate at North Carolina Central University, where I got a degree in mathematics. I grew up in Robeson County, and from 1980 until 2003, I was in the North Carolina House of Representatives. 2 terms during that period, I served as Speaker of the House. And I left in 2003, came back to the House in 2006, and since 2009, I've served in the Senate. I currently serve as the Democratic leader in the North Carolina Senate.
And your legislative career spans almost 4 decades, I believe.
About almost as long as I've been around. Yeah, actually, 4 decades.
Yeah. And have you had the opportunity over those decades to participate in the consideration and adoption of maps redrawing our legislative and congressional districts?
I have. I began, as I said, I was first elected to the House representing Wake County, the entire county in 1980, and in 1981 I was intimately involved in the redistricting effort during that time, in 91, 2001, and 2011. And all but the year 2011, I served on the redistricting committees. In 2011, I wasn't on it, but I was still very involved in the redistricting process.
And let's focus on this decade's redistricting. You were in the legislature in 2011 when the congressional and legislative maps were first drawn.
I was.
And you participated in that process.
I did.
Yes. You were an active participant, I believe.
I was an active participant. They just wouldn't put me on the committee.
And what about the 2016 redrawing of the congressional map? Were you a participant in that?
I was a very active participant in that, and by that time I was back on the committee.
Okay.
Committees.
And what about the redrawing of the maps, the legislative maps in 2017? What role did you play there?
Well, I mean, I was involved in it. I was, as the Democratic leader, I was working first with the Democratic Senate members on the redistricting plan, but sort of communicating with the majority leadership on it and just trying to figure out generally what was going on.
And were you a member of the Senate Redistricting Committee in 2017?
I was.
Okay. Now, which party had control of the legislature in 2011, 2016, and 2017 when all these maps were drawn?
Republican Party.
And what level of control did the Republican Party have in each of those years?
Had total control. They had a supermajority and had a supermajority in both chambers in 16 and 17, in the Senate in 11, and they didn't get the supermajority in the House until 2012.
And what was the impact of that level of control on the Democrats' participation in the redistricting process?
Yeah, you were a good footnote. I mean, in the sense that with a supermajority in any legislative body, basically whoever's got it does what they want to do, and the other party is sort of relegated to sideline activity.
And did the same person draw the House and Senate and congressional maps in 2011, the new congressional map in 2016, and the new House and Senate maps in 2017?
For the most part. In 2011, the House chair...
No, I'm asking who drew the maps. Who drew the maps?
The Republican Party.
Okay.
Yeah.
And did they have a map drawer?
Oh, yeah, they did have a map drawer. A rather interesting guy. Dr. Hoffler.
Okay.
Was retained by the leadership to draw the maps in 2011, 2016, and 2017.
Okay. And who is Dr. Hoffler?
Tom Hoffler was, I think he was referred to in some of, I think the New York Times or somebody, the Michelangelo of partisan gerrymandering redistricting.
Okay. Now, who gave directions to Mr. or Dr. Hoffler in drawing the maps in 2011, 2016, and 2017?
That would have been the chairs of the Senate and House Redistricting Committee, and that was the point I was going to make a moment ago. In 2011, it was Senator Rucho for the Senate and Representative Robert Rucho and Representative David Lewis for the House. That was the same situation in 2016. In 2017, it was still Representative Lewis, but Senator Heiss replaced Senator Rucho, who had left the legislature.
And it's correct, I believe, that Representative Lewis was the person who gave directions to Mr. Hoffler with respect to all three of these sets of plans.
That's correct.
Okay. So let's go back to 2011 in a minute and talk about the legislative maps. What was the partisan impact of the 2011 legislative maps?
The 2011 legislative maps, in the case of the Senate, they were drawn to preserve the supermajority that the Senate, that the Republicans had won in 2010. In the case of the House, they were designed to create a supermajority because, as I mentioned earlier, the House was 4 or 5 votes short of a supermajority by the Republicans after the 2010 elections.
And I believe 3 elections were held under those 2011 maps in 2012, 2014, and 2016, correct?
That's correct.
And did the Republican Party obtain a supermajority in the House and the Senate at each of those 3 elections?
Yeah. Again, the 2010 election created a supermajority in the Senate. 2012 elections created a supermajority in the House, and in the Senate each year after that, each election after that, the supermajority in the Senate increased by 1 each cycle.
So at each of the 3 elections under the 2011 legislative maps, the Republican Party had, at those elections, a supermajority.
Supermajority, and it got more super after each election.
Let's talk just a minute about the 2016 congressional map. What was the aim and the impact of that 2016 redrawn congressional map?
To preserve the supermajority that had been created in 2011 by the Congressional Redistricting Committee, and to keep, I think it was stated by Representative Lewis that the goal was.
Objection, Your Honor. Pardon me, and I beg your pardon to interrupt you. We have a couple of issues here. I believe we're about to tread into an area of hearsay, and we're already in an area of relevance. He is testifying about the congressional plan, and we are not in a case where the congressional plan is being challenged.
Your Honor, the same persons drew all these maps, the same persons directed the drawing of all these maps. Representative Lewis is a defendant in this action. He's not here because he has asserted a legislative privilege and will not come to court and explain what they've done. The record that is in front of you contains or will contain the statements of Representative Lewis, and in addition, it would be the admission of a party opponent. Senator, were each of the 2011 and 2016 maps accompanied by something called a stat pack?
That's correct.
And what is a stat pack?
It's short for statistics. Stat pack is the set of statistics explaining each of the maps or each rendition.
And would the statistics examine the expected partisan impact of those maps?
The stat pack would contain a lot of stuff, a lot of mundane stuff, but also give you a breakdown of party affiliation, the tendency of folk to vote certain ways in certain districts. It would have pretty in-depth analysis of what those maps represented.
And would it have the analysis of past election results?
It would, at least the way the stat packs were assembled for this round of redistricting. It had, I think, 8 or 10 specific elections over a decade or some similar period, but it would show what the results had been in specific configurations of districts on a partisan basis over a certain amount of time.
And what the people in the legislature might expect going forward.
I'm sorry?
And what the people in the legislature might expect with respect to the impact of the partisan impact of the map going forward.
Well, they were pretty reliable predictors, not 100%, but pretty reliable predictors of how these districts would perform in the future based on how they performed in the past.
Let's focus specifically on the 2017 process, Senator. Who appointed the members of the redistricting committees in 2017?
The President Pro Tem in the Senate and the Speaker of the House in the House.
Okay. And who did the President and Pro Tem and Speaker appoint as chairs?
fellow Republicans, and the House, as I indicated, not only Speaker Moore, but his predecessor appointed David Lewis as the chair, and in the Senate, Senator Berger, the President Pro Tem, appointed Senator Rucho, and subsequent to Senator Rucho's leaving the legislature, he appointed Senator Heiss.
Okay. And how many Democrats and how many Republicans were appointed as members of these redistricting committees?
Roughly, it was about 2/3 Republican, a little more than 2/3 Republican, and about 1/3, or a little less, 1/3 Democrat.
So is it fair to say that the Republicans had a supermajority on these committees?
That's fair.
I believe, Senator, that the first official action to redraw the 2011 maps was an organizational meeting of the House and Senate redistricting committees, a joint meeting on July 26th. Do you remember that?
Yeah, I remember.
Okay.
There was a meeting.
Senator, there's an exhibit notebook in front of you. If you could direct your attention to the first exhibit in this notebook, which is Plaintiff's Exhibit 601. I would like to ask you whether at this organizational meeting, Mr. Hoffler's role in the redistricting process was discussed.
It was.
And what was that role as you understood it?
To redraw the districts as he had drawn districts in 2011 and 2016.
And Senator, I would direct your attention to page 23 of Exhibit 601, specifically lines 3 to 6, and ask you to read those 3 lines into the record, please.
That's the quote by
Representative Lewis?
Representative Lewis, yes. The print on the computer is bigger, so I'm cheating a little bit. I'm reading it. It says, Representative Lewis, the statement, Dr. Hoffler is working as a consultant to the chairs with the approval of the Speaker and the President Pro Tem of the Senate. So the short answer to your question is no.
Okay. And was that, he's speaking in response to a question from a Democratic member about whether Dr. Hoffler would be available to the Democrats?
He was. One of the members, may have been Senator Van Dyne or either Clark, had asked whether Dr. Hoffler would be available for questioning by the Democrats.
And the answer
so he was answering no.
Yeah. And were questions raised at this first meeting on July 26th about whether Mr. Hoffler had already drawn maps?
Questions were raised about that.
And how did Representative Lewis respond?
Representative Lewis indicated that there were no maps that had been drawn to his knowledge.
Okay. And I would direct your attention, Senator, to page 11 of Exhibit 601 and ask you to read into the record from lines 23 on page 11 to the second line on page 12. And this is Representative Michaud asking a question at line 23 on page 11.
Page 11.
Page 11 of Exhibit 601. At the bottom of the page, Representative Michaud is speaking.
And that's what's on the screen, I take it. That's not what I'm saying here.
Okay, can you read the screen then?
Okay. Are there any other maps that have not been released? For instance, anything that has not been drawn, that has been drawn by Dr. Hoffler or anybody else that you know of that have not yet been released? Representative Lewis, none that I know of, sir.
Okay. Was Representative Lewis asked if he planned to hire additional consultants?
He was, and he indicated that he had no intentions of hiring additional consultants at that time.
And I would direct your attention, Senator, to page 23, lines 15 to 19, and ask you if, well, actually, let me just withdraw that question. But was the next committee meeting on August the 4th?
July 20, yeah, August 4th.
And was this another meeting of the joint committees?
It was,
And what was the purpose of that meeting?
to talk about the criteria for the redistricting.
And did Representative Lewis preside at that meeting?
He did.
Okay. Did Representative Lewis share any information about the process that would be followed in redrawing those maps?
He indicated that basically the committee would adopt certain criteria, and once that criteria was adopted, then he would order Dr. Hoffler to commence drawing maps. And of course, that there would be an opportunity for public input, public hearings on it. But in essence, that's what the committee meeting was about.
And Senator, I would refer you to page 72, Plaintiff's Exhibit 602, lines 12 to 14, and ask you, have you found that?
72,
Page 72, Exhibit 602,
602.
lines 12 to 14, beginning with "and." Would you read that in the record?
And once this committee has adopted it, I will instruct the map drawer to begin using that criteria to draw the map.
And is that Representative Lewis speaking on that
That's,
occasion?
that's the last sentence of Representative Lewis's statement that began on line 3.
And to your knowledge, was that the process that was actually followed in drawing up these maps?
As best I can tell.
Did the question of whether Dr. Hoffler had already drawn maps come up again at this meeting?
It did.
And I would direct your attention, Senator, to page 72, beginning at line 20, and ask you whether or not on that occasion Representative Michaud asked this question: can you assure this body right now that no redistricting maps have yet been drawn? Did I read that right?
You read it correctly. That is exactly the quote in there.
And could you read for the court what Representative Lewis said?
Thank you for the question. I can assure this body that none has been drawn at my direction and that I have direct knowledge of. The only map I'm aware of was submitted by an independent group and presented to this committee last week.
Now, Senator, at the end of this August 4 meeting, do you recall the committee, Representative Lewis, inviting citizens to speak about the proposed criteria?
Yes.
And do you recall what those individuals said?
I think there were about 20 people speaking at a public hearing related to the redistricting. And overwhelmingly, they were saying that they wanted districts drawn that were not partisan in nature, not partisan gerrymanders.
Senator, I would direct your attention to page 33, line 17 of Exhibit 601, and ask you if that and the following lines contain comments by a Ms. Heather Simon. It's page 33 of Exhibit 601.
Okay.
Did you find that?
I see it on the screen.
And would you just read into the record what Ms. Simon said, beginning at page 33, line 17, and continuing over to line 11 on page 34.
Heather Simon. My name is Heather Simon. I'm from Cary, North Carolina, and I'm here representing myself today. I took time off work today to come comment because nonpartisan redistricting is fundamentally about preserving our democracy. The redistricting process is only happening today because the legislature failed to create legal and constitutional districts in the first place. The fact that you have again hired the same consultants to draw the hyphen that drew the current illegal maps is troubling. The legislative redistricting process must be carried out in a nonpartisan manner, ideally by an independent commission and with the opportunity for the public, again hyphen, the public to comment on the final district maps. To guarantee that the process remains fair and unbiased, the legislature should exclude political information like voter registration data and past election results when drawing maps.
And Senator, did other persons express similar sentiments at this public hearing?
Yes, that was the sentiment, basically cursing through most of the testimony at the public hearing.
And did you see any indication that the legislature or the majority in the legislature took any heed of those comments and views of citizens?
No, the record shows and experiences that they're just the opposite.
Senator, was the next meeting of the Redistricting Committee on August 10, 2017?
That's correct.
And was this the meeting at which the committee met to adopt criteria that Lewis and Heiss would then direct Hoffler to use to draw the maps to bring back to the Senate and the House?
That was the stated purpose for that meeting.
Yeah. Were you there?
There was one that I was absent. I was there telephonically. I had to be in Washington. Okay. And it was that one or the one before, but I read the transcript. I was in constant communication with it. I think that this was the one that I was absent, but I was in D.C. talking to the Democratic senators on the committee about the criteria.
Have you read that transcript cover to cover?
I have, sure.
Okay. Was one of the criteria that Representative Lewis proposed was to direct Mr. Hoffler to use election results and consider partisan advantage in redrawing the districts?
That was one of the criteria.
Okay, I will direct your attention now, Senator, to the next exhibit, which is Exhibit 603, and specifically to page 132, and specifically to lines 9 to 15, and I would ask you if you would read those lines into the record.
Representative Lewis. Thank you, Mr. Chairman. This criteria reads election data. Political consideration and election results data may be used in drawing up legislative districts in 2017 House and Senate plans. I believe this is pretty self-explanatory, and I would urge members to adopt the criteria.
And what did you understand this criterion to direct Mr. Hoffler to do?
I understood the criteria to be to include that as one of the 8 or 10 criteria to direct Dr. Hoffler to go and draw maps that preserve the same supermajorities as had been drawn in the earlier maps that he drew. He had the same data, the same information.
And what data was he to use to do that?
He was going to use part of the stat pack. The stat pack shows some of the data that he would use would be the election results of certain elections before 2017 and the specific political results that those elections represented. Who won, what they won by, percentages, makeup, and things like that.
Did this direction to Mr. Hoffler pass the committee?
It did, along a party line vote.
Did any Democrat vote for this criterion?
No.
Did the Democrats propose a counter amendment to this amendment?
Yes, I think it was Senator Clark.
Okay. I direct your attention to Exhibit 603, page 166, line 20, and to the next page, and ask you whether this is a spot in the meeting at which Senator Clark proposed that a counter criteria.
Okay, starting on
Page 166,
166,
line 19.
line 19.
Senator Clark, would you read what he said into the record?
Senator Clark, okay, when we were doing the 2016 congressional redistricting process, it was stated by Mr. Lewis here that one of the express purposes was to maintain the partisan advantage. I guess you could say this is a renouncement criteria, if you will. And it states that maintaining or establishing a partisan advantage for any party shall not, emphasize not, be a criterion for the construction or approval of House and Senate district maps, plans.
And did Representative Lewis speak against that amendment?
He did.
And did the amendment fail?
It failed, again, along party lines.
Okay, and every Republican voted against it.
Every Republican voted against the Clark Amendment. Every Democrat voted for it.
So, Senator, let's now go to the next meeting, and I believe that was a meeting of the Senate Committee on August 24, 2017. Do you recall if you were there?
I would have been at that one.
Yeah. And what was the purpose of this meeting?
To take a look at the maps that had been drawn.
Okay. And did Senator Heiss preside at this meeting?
Senator Heiss presided at that meeting.
Did he explain what Mr. Hoffer had done with respect to carrying out the partisan consideration direction?
Yep, he did.
I would direct your attention, Senator, to page 102 of Exhibit 606, and I'm sorry, I've taken you to the wrong place.
Yeah, okay.
Would you look at page 10 of Exhibit 606, line 16?
Page 10, line 16.
Yeah, and is Senator Heiss explaining the criteria and how they were carried out at that part of the transcript?
He is explaining the criteria, and that specific one, he's explaining incumbency protection.
Would you look at line 16 on page 10? Do you have page 10 in front of you? Does it begin criteria number 8, election data?
Yeah, and I apologize. I've been looking at the actual pagination on the bottom as opposed to the top, and they're conflicting. That's why I've been somewhat confused.
It is confusing,
Yeah,
I can tell you that.
The official record has page 10. So, okay, so at page 10 of the actual transcript up in the top right corner.
Yeah, line 16.
Line 16, criteria number 8, election data.
And would you read into the record down to page 24?
Sure. Criteria number 8, election data. Political considerations and election data may be used in the drawing of legislative districts in the 2017 House and Senate plans. For this purpose, we selected 10 races from 2010 to 2016. The 2010 U.S. Senate race, 2012 presidential, governor, and lieutenant governor race, 2014 Senate race, and the 2016 president, U.S. Senate, governor, lieutenant governor, and attorney general races. So you should have information on each of those in your stat pack.
Okay. Now,
States it's
yeah.
few minutes past 1, so we're going to recess for lunch at this time. We'll resume at 2:30.
Spirit course and recess until 2:30 exactly. You guys say the state's not over.
afternoon. Good afternoon, welcome back. We'll pick up right where we left off. Senator Blue and I believe Mr. Spees.
Your Honor, one quick question. Would it be possible for the court to advise how late we plan to go this afternoon, or how late we can go this afternoon?
Right, so we typically recess at 5 o'clock in the afternoon, start 9 in the morning, break somewhere between 12:30 and 1, hour and a half recess, and then we generally recess around 5. I know that you mentioned in one of our pretrial conferences that you had some folks with travel schedules.
Yeah, today is the main day where we have a couple of the witnesses who do have some limitations. We'd like to get them done. We'd certainly do our best to get it done by 5, but if there was enough ability to go, a little bit beyond, particularly for one of the voter plaintiffs who's here, whose testimony will be short. But
Right. A little bit beyond is fine, but, we have folks that are working really hard and there's only a certain amount of capacity that we can do, but a little bit beyond 5 might be possible. But please don't abuse that discretion.
we will. Thank you.
All right. Mr. Spees.
Thank you. Your Honor, Senator Blue, when we recessed for lunch, we were on Exhibit 606, page 10, at which time you had read into the record criterion number 8, which is political considerations on election day that may be used in the drawing of districts for 2017, and then identifying the particular districts that were used. Let me now, Senator, direct your attention to Exhibit 597 in your notebook. And would like to ask you is whether Exhibit 597 is the stat pack showing the election results for the 10 elections that Hopper used in drawing this map.
That's exactly what it is. It's the stat pack for this map.
And was this in front of the legislature when it was enacting the Senate plan?
This stat pack was, yes, it was available to legislators who wanted it.
And could you briefly describe for the court what is in this fairly detailed document, lots and lots of numbers, but beginning maybe on the left column and walking through, and then I maybe ask you to give an example.
Okay, as I was explaining the stat pack earlier, it's got a lot of mundane stuff. The entire makeup of the district, say if it's a Senate district, and that's what this is, the ideal population is 190,000 plus. And so it'll have the breakdown of that population. In this case, it should have the 2010 census data. And overlaid on that is Democratic percent and the Republican percent. And then it'll break that down in each race that we're looking at. In this case, all 50 Senate districts. Having those 10 races that I described earlier overlaid on the individual districts.
And could you or anyone else in North Carolina look at this data and know how your Senate District 14 would have performed under each of these 10 elections?
Pretty much so. I will know how it performed in all 10 previous races that were looked at to determine what this district would perform as, and make a pretty safe bet as to how it was going to perform after it was enacted in the law.
And while citizens could look at your district, could they look at the entire plan and also make an estimate of how the map would perform as a whole in all 50 districts?
Pretty much so. Having some baseline knowledge of what these districts were, who they were, party affiliation and stuff like that, a layperson could look at them district by district by district and pretty confidently predict how they would perform over time in the next election and subsequent elections.
And did the members of the Democratic Party in the Senate in 2017 look at this data and make any estimate of what the impact of the plan would be?
You could look at it and tell precisely what it would probably do, knowing beforehand what the intent of it was, at least as it was drawn, the perception that we had as to what the intent was.
And by your count, would this map have preserved did the 2017 map likely preserve the supermajority in the Senate?
It would have, and given the other elections for the decade that we had studied, this map was designed specifically to preserve the supermajority, but it had another feature built into it as well. It had a fallback position. Even if it couldn't preserve the supermajority, it was clearly designed to have a perpetual majority. And we saw this as we analyzed it before it was enacted.
Let's talk about the 2018 election
Okay.
a little bit. So going into the 2018 election, knowing you were going to be using these new districts, what did you think the prospects for the North Carolina Democratic Party were in the Senate?
Realistic prospects. In 2017, when we drew the maps, because there were several districts that had to be redrawn from the others, specifically in the urban areas, we knew that there would be some pickups, specifically that there would be a pickup in Wake County based on the redrawn maps. I mean, that was pretty much assured because a new district was drawn that had a 60-some% Democratic performance based on these races that we talked about being overlaid on the district. There was a new district in Cumberland County, different district, down in the Fayetteville area. There was a new one, a different one in Guilford County in Greensboro. So we felt pretty confident that we could win those districts if the stars lined up correctly. So going into it safely, we knew that there were at least, we had 15 going into it, we knew that there were at least 18 or 19 districts that probably would perform democratically, even though they may not have performed up to 50% in the previous election, but because of the redistricting and stuff.
And how many votes, how many seats would it take to break the supermajority?
Would have taken 6 seats to break the supermajority.
In the Senate, to break a supermajority, the Democrats would need
21.
50 seats.
Would need 21 to break it. 20, since the supermajority is 60%, we needed something so that they would not have 60%.
And what happened at the 2018 election?
We won 21 seats.
And what percent of the vote did you get?
A little over 50% of the vote.
And how were you able to do that? How did the Democrats break the supermajority barely?
And it was barely, at least in one race. I think the final count was 37, 38 votes. We spent more money than we'd ever spent because we were able to raise more money than we'd ever raised. There were some crosswinds in the Republican camp because of some of the legislation they had passed. There were a lot of groups that were working to break the supermajority because the governor was intimately involved in it. His entire agenda had been frustrated. And so you had all of those things coming together. Plus we had some, I think, excellent, magnificent candidates who themselves were able to raise more money than typically candidates who are not in power are able to raise.
Did you believe you could break the majority? We were just talking about the supermajority. What were your views about getting the majority of Democrats elected to the Senate in 2018?
Well, you sort of wish every now and again a tsunami might come along, and we wanted to be prepared in case one came. If the boats were lifted, we at least wanted to have boats that were built well enough that they could rise with the tide. but you know, realistically, we were following the polling data in all 50 districts. For the first time, in my memory, we had candidates running in all 50 Senate districts. And some districts there was a heavy push by the Libertarian Party to have candidates, so they were probably on about half of the ballots. So many Senate races involved 3 candidates, a Democrat, a Republican, plus a Libertarian. And so we were pushing as hard as we could, and we were trying to convince people that we could break the majority. That was the name of one of the fundraising efforts that the governor headed up, called Break the Majority.
But you weren't able to do so.
No.
And why not?
Well, several reasons. Number one, I certainly epitomized hope, so I told people that I thought that we could break the majority. And again, I didn't tell them the circumstances under which we could probably do it, but we could not break the majority because of this sort of double fence. If you're a hurdler, you know, the second hurdle got higher than the first. And the first one was to protect against breaking the supermajority. And if the wave topped that, then there was a second hurdle built to protect the majority. And that's the sort of area that we're in now, both in the Senate and the House. And I think that even in almost an ideal situation, with the resources, with the most visible politician in the state, the governor, out on the hustings every day campaigning for legislative candidates, with great candidates who embodied what their communities were about, we were able to break the supermajority, but the majority is still a reach, even though we got more than 50% of the vote. And looking back on it, analyzing it, it would take in excess of 55% of the vote to break the majority based on what we saw in the 2018 elections.
Your Honor, I would object to that on the note that that appears to be expert witness testimony, not testimony by a lay witness.
Your Honor, this is a 40-year veteran of the North Carolina legislature who has participated in the assessment of their political chances. Okay. So, Senator, just to recap, your view was you had an opportunity to maybe breach the wall, the seawall, protecting the Republican supermajority, correct?
That's correct.
And you did right on the money.
We did, right on the money.
But you didn't believe you had any realistic opportunity of breaching the second seawall, the one protecting the Republican majority. Is that correct?
Except in extraordinary, unforeseen, non-happening circumstances.
Like 55% of the statewide.
Or greater.
Thank you.
Cross-examination? Yes, ma'am. Ms. McKnight?
Good afternoon, Senator Blue. It's an honor to meet you,
My
but I will
pleasure.
try to keep this brief today.
Okay.
The first thing we're going to do is pass out a witness notebook with some exhibits we can discuss.
Okay. Thank you.
Senator Blue, do you have that binder in front
I
of
do
you?
have it. Thank you.
Great. I'd like to start on a topic that should be non-controversial, so bear with me. I'd like to ask you a few questions about your role as a senator.
Okay.
Now, Now, your role as a senator involves more than just working on legislation. Is that right?
That's correct.
And you would agree that senators serve a certain ombudsman role, right?
Yeah, we do.
And now, when constituents contact you, you do not inquire whether they are Democrat or Republican. You try to help them regardless of their political affiliation. Is that right?
In all circumstances.
Okay. And you believe that you represent all constituents in your district regardless of their political affiliation. Is that right?
Absolutely. Following Election Day, everybody's entitled to have a senator who's responsive to their attention, to their needs, at least as far as intervention with government and other factors like that are concerned.
And you believe that your Republican counterpart in the Senate, and that would be the president pro tempore of the Senate, is offering the same type of constituent services?
I certainly hope so. I don't necessarily agree, because I think that President pro tem is a good senator. But the makeup of your district basically determines what kind of constituent service you do, and the more diverse a district is, the broader the kinds of services that you do, and the greater understanding that you have, not only of that district, but on a statewide basis of what the needs might be.
I see. And so, do you recall being asked this question at your deposition?
Yeah, I tend to recall that, yeah.
And at the time, do you recall testifying that you had no reason not to believe that the president pro tempore of the Senate was also offering the same type of constituent services?
And I still believe that. But I'll give you an example why I say the answer that I just did. We're in the middle of the throes of the budget right now. And one of the issues that came up, and I talked extensively with the president pro tem about it, is that none of the members of his caucus had historically black schools. There was an exception, one in the Northeast and one with one of the private schools. And all of the others in the state of North Carolina has more historically black colleges and universities than any other state in the country, but all of the others were in Democratic districts. So the point that I was making with him, and we finally prevailed, is that you get a different perspective of what the needs are when you represent these schools and you go by them than you do getting a report from the Board of Governors. And so it's that kind of stuff that I'm talking about. But no, I think the President Pro Tem does an excellent job in representing the interests of his district.
I'd like to move now to the 2018 election. In that election, you were in charge of candidate recruitment for Senate Democrats. Isn't that right?
I, along with a committee, as the leader of the Senate caucus, ultimately, the buck sort of stops with me, but right now I have 20 other senators who are very talented, and I'd much rather give them a whole lot of stuff to do than do it myself. But ultimately, yeah, we had a committee that was responsible for recruitment. I dropped in and out of their meetings, but I did not chair the committee.
And at that time, you had a goal to recruit good candidates in all 50 Senate districts, correct?
Absolutely.
And you met that goal?
We had candidates in all 50 districts.
Do I understand you to say that you believe you did not have good candidates in all 50 districts?
No, I didn't say that. We had, our goal was to have good and great candidates in all 50 districts. We had candidates in all 50 districts.
I think I'll leave that one, Senator. Thank you. Now, regarding fundraising, I heard you just testify that you raised more money than you ever raised.
Yes.
Is that right? Now stepping back in time to the 27 redraw of the enacted plan. Now in 2017, you were a member of the North Carolina General Assembly Senate Committee on Redistricting, correct?
That's correct.
And at that time, your work focused on the Senate plan. You were not engaged in what the House districts look like, right?
Not engaged intimately, but understand, this is what we do. We pay hundreds of thousands of dollars to consultants who come in and tell us what the strategies ought to be. And one of those was to try to look and see where Senate districts overlap House districts, where the House caucus was making a sincere, serious effort to win a district. And so we had to have some knowledge of where that overlap was, so that if there was a possibility of overlapping resources, we wanted to know about it, or overlapping themes that are running through the campaigns of those various candidates. So in that sense, I knew what some of the House candidates were up to and what they were doing and how they were being recruited. But no, I had no responsibility for recruiting House candidates, training them, helping them fundraise or anything like that.
And pardon me, Senator Blue, I may need to cut you short at certain points, candidly out of respect for your own counsel's request that we keep things moving along. I will try to ask precise yes or no questions. Your counsel will have time to redirect if it's necessary. Do you recall testifying at your deposition that you were not engaged in what the House districts looked like?
And that's true.
Thank you.
True.
Now, I heard you testify earlier that Representative Lewis did not hire additional map drawing consultants for use by the Democratic caucus. I also heard you testify that you, as part of the Democratic caucus, did not have access to the Republican caucus's consultant. Is that a fair description of your testimony?
Part of it is. I didn't testify that Representative Lewis didn't give us resources. But he did tell us that we couldn't get access to Dr. Hoffler.
Okay.
And the reason that I answer that is that there were resources allocated to at least the Senate caucus once we got the redistricting process moving down the road.
Thank you for that testimony, because that was a question. The Democratic caucus did receive state funds to hire its own map drawing consultant. Isn't that right?
We got state funds sort of in the last 20-30% of the process to have someone come and draw maps, and I chose not to have them draw overall maps, but to sort of work and advise me on what some of these other maps that had been drawn looked like.
And so, in fact, you did hire a map drawer, Dr. Kareem Creighton, and he helped you draw several amendments that you made to the map. Isn't that right?
He helped some members in drawing adjustments to some of their districts.
Okay.
But he worked, if I could describe him adequately, we found him in Alabama or Mississippi 2 or 3 weeks before the maps had to be completed. And he couldn't do, as I recall, just a thorough drawing of the maps as as a Republican consultant had done. So we basically had him looking at specific little maps, for example, maybe the Greensboro redraw or the Fayetteville redraw, but not the overall map as we ended up enacting.
Right. And in fact, he helped you prepare 2 amendments that you submitted to the map, correct?
Kareem may have helped me with the Wake County amendments. We did 2 amendments for Wake County on my behalf and Senator Chaudhry.
And now, I understood your earlier testimony when you were describing Dr. Creighton that you found him in Alabama a few weeks before, but in fact, he had a lot of experience and expertise in North Carolina. Isn't that right?
Yeah, and I might be wrong. He may have been in South Africa. He had been a professor at the law school at UNC Chapel Hill, and was sort of, he was a political scientist, lawyer, and all of those combinations. And he was between jobs, but he was doing something in South Africa at the time. And we had him just come take a look. He had been here when he was on the faculty at Chapel Hill, working with the Black Caucus, I think, in 2011, maybe, I think it was 2011, it may have been 2016, but I hadn't worked
Thank
directly
you.
with him on that.
Okay, thank you, Senator. And when Dr. Creighton did work for you, you did not provide access to Dr. Creighton for the Republican caucus, did you?
They never asked.
Is the answer no?
I didn't, nobody ever asked me to provide them to him.
Okay. Now, in 2017, during the redraw, your chief of staff, in fact, scheduled redistricting data review appointments for Senate Democrats in July 2017. Isn't that right?
He probably did, because using a central point, and I don't know, I mean, but he sort of works for the whole caucus, and so he probably was scheduling time for them to look at what their districts look like.
Now, we've been talking about amendments that you proposed to the maps. I'd like to move to discussing those amendments now.
Okay.
First, you adopted 2 amendments to the Wake County districts, and both were adopted by the committee. Isn't that right?
That's correct.
And you believed that these amendments fixed the racial gerrymander in Wake County because you said at the time the racial percentage in one district, Senate District 14, was decreased from about 38 to 39% down to 32 or 33%. Isn't that right?
That's what they were reduced down to.
And not only is that what they were reduced down to, but you believed that that decrease fixed the racial gerrymander in Wake County. Isn't that right?
That was my opinion, because understand, since 2002, 2003, nobody had done any disparity studies in Wake County to determine how you would satisfy the Jingles criteria. And so once I saw that they were taking the percentage of black voters in the district up to the level, or higher level than had been historically the level, I was concerned that they were still using race as a primary criteria in drawing these districts. And having discussions with the leadership of the, at least the Senate side in redistricting, I basically made the point to them that there is no reason to still dump this many African American voters in the same district, because now you can put them in 2 districts, and you will basically preserve communities of interest, the way they relate to each other, and not just have them all packed into the same district. And so everybody went along with it, and it was my opinion that that would have fixed any potential racial gerrymander claim against the Wake County portion of the map.
Thank you, Senator. I'm going to ask you some questions about the criteria that was applied in drawing the maps in 2017. Let's turn to LDTX, that's Legislative Defendants Trial Exhibit 7. Now, page 2 of that exhibit is titled 2017 House and Senate Plans Criteria. Do you see that?
I do.
Okay. And would you agree that this is the criteria that was used to draw the maps in 2017?
I will agree that this was the criteria adopted.
Thank you. And now I'd like to take a look at a few points on this sheet.
Okay.
The third criterion down lists county groupings and traversals. Do you see that section?
I see that.
Okay. Here, I think it may be useful in discussing the county groupings and traversals criterion to look at a map of the enacted plan. If you turn to LDTX2, it's the first tab in your binder, you can take a look at the enacted plan from 2017.
Two, I have it.
Okay. Now, to orient everyone to the legend, in this map, the bold black lines in the state signify county lines, and the thin blue lines signify district lines where they do not comport with the county lines. I see that each Senate district is filled with a different color. Do you see that?
I do.
So evidence of the whole county rule, for example, can be seen in Senate District 1 in the far east of the state. It's shaded in pink, where you cannot see any thin blue county lines because the district contains 11 whole counties. Do you see that?
I see it.
Okay. And the same is true for Senate Districts 2, 3, 4. You see whole counties grouped together within one Senate district. Do you see that?
I do.
And do you agree with me that that is the reason those districts were drawn that way was in part to comply with this whole county rule?
And the criterion developed in Stevenson, or one of the 2003, Stevenson rather than Strickland, yeah, cases from our Supreme Court.
Okay, thank you. And so we can turn back to LDTX 7, the criteria. Now that we've discussed the county groupings and traversals, looked at a small example of those rules, I wanted to move on to the fourth criterion down. It states that the committees shall make reasonable efforts to draw legislative districts in the 2017 House and Senate plans that improve the compactness of the current districts. Do you agree with me that that's what that requirement is?
That's that criteria, yeah.
Let me make sure I understand that criterion properly. That does not mean that the Senate would only pass plans that optimized compactness, meaning the Senate would only pass plans that made the most compact districts possible, but rather that the Senate would make reasonable efforts to improve upon the existing map. Do you agree with that?
That's first sentence says that they'll make reasonable efforts to make them more compact.
Now, the fifth criterion is a little similar. It's different, though. It focuses on fewer split precincts. Again, the criterion seems clear that the obligation on the Senate committee was to make a reasonable effort at improvement. This did not mean that the committee could only pass plans that split as few precincts as possible. Would you agree?
I agree with that.
Thank you. Going down to the sixth criterion, it appears there is a requirement that the House and Senate committees respect municipal boundaries when drawing legislative districts, that they may consider them. Do you agree with me that that's a criterion?
That they could look at municipal boundaries and decide not to split them. Yeah.
Thank you.
Not compulsory, but sort of suggested they might want to do that.
Senator Blue, I would like to look at the two amendments that you proposed to Wake County. Those amendments are located at LDTX 37 and LDTX 38. What you might do, I'm going to be asking you questions about the maps.
Okay.
The map for LDTX 30 is at 37 is at page 4. You might pull that out of the binder, Senator. It may make it easier to compare it.
This map.
That's right. And now the map for LDTX 38 is on page 2.
When is before and when is after? Is that what it is?
That's correct. I will. set the record for this, Senator, so it's clear for everyone. You'll note on LDTX 37-4, that map notes that it was printed by the NC General Assembly August 23rd, 2017.
Okay, you got me a little confused. I'm trying to find the nomenclature on it. 30 is the first one, right?
That's correct. 30 is the first one.
And 122 is the second one.
Correct.
I got that.
And this is part of the related exhibit. The related exhibit will show that the map titled AMT 30 predates the map titled ATC 122.
Okay.
Now, Senator Blue, the public record reflects that both of these amendments were submitted by you in committee. And the record also reflects that both of these amendments were adopted.
That's
Does
correct.
that comport with your memory?
Absolutely.
Okay. First, to orient everyone to these maps. The thick blue line indicates a county grouping. The black lines indicate county borders. The thin blue line indicates a Senate district line. Senator Blue, do you agree with how I've described the legends on the maps?
Yeah, there's a black line between Franklin County and Wake County and a blue line between Durham County and Wake County. So everything within Franklin and Wake County is a grouping.
Now, there's some similarities between the maps. Let's start there. Both maps draw 5 Senate districts in Wake County. Those are Senate districts 14, 15, 16, 17, and 18. And both maps have Senate District 18 bleeding over into Franklin County to the north. Would you agree with that?
Yes, Franklin County is a whole county. It couldn't be split. A whole county without enough people to have a separate Senate district carved in it, so it couldn't be split.
I see. Thank you. Now, at the time you introduced these amendments, and specifically at the time you introduced the second amendment, you believed that of these 5 Senate districts we were just discussing, they created 2 strong Democrat districts, 2 strong Republican districts, and 1 competitive-leaning Democratic district. Isn't that right?
Yeah, my quick perusal was this. There were 3 Republican districts in Wake County, 2 Democratic districts that were drawn in 2011. One of those districts in Wake County was a racial gerrymander based on the Supreme Court ruling. And so when they came back to redraw them, they took the Wake County district that was a racial gerrymander down from roughly 50% African American population to the high number you just mentioned, 38, 39. And by the same token, because of the results of the stat pack analysis that you saw earlier, one of the Republican districts in Wake County had trended Democratic very quickly during the decade. So they drew one of the former Republican districts as a Democratic district, 60-some% performance. And so there were 3 Democratic districts that performed at the 60 to 65% level in these races that you had just talked about, that were in the stat bag. And what this amendment was doing was trying to adjust the numbers between the 2 districts that still had, not the numbers, the makeup of the 2 districts that still had the substantial minority population. One was 38, 39, the other one was 31, 32. You could shift the population between the 2 of them without having done any jingles analysis. And I think justify the fact that you weren't creating a minority district, or a district that had an overwhelming number of minorities in it without having conducted the Jingles analysis showing that it was necessary. So that's what we did with District 14 and 15. District 18 on these maps, you couldn't bother because it was designed as a Republican district. And that's why I offered the amendment the way I did. It did not interfere with the way they have rearranged the districts in Wake County, including the Franklin County addendum to it, as far as Democrat or Republican. You didn't substantially change the Democratic performance within 15 and 14, but you cured the racial issue if a racial issue, if someone had attempted to show it.
I see. So you would agree with me that at the time you believed that of these 5 districts, you had 2 strong Republican, 2 strong Democrat, and 1 leaning Democrat?
Based on what I just explained to you, there were 3 districts that had roughly 61% plus Democratic performance, 2 districts that had 47, 48% Republican performance. Again, based on these numbers, because of what had been happening with legislation and what have you over the decade, what were solid Republican districts were trending Democratic because of the issues in the 2 strong Republican districts. I characterized them as strong because they were less than 50% Democratic performance.
I see. I'd like to put up on the screen Legislative Defendants Trial Exhibit 9.
Okay.
Now, Senator Blue, this is titled General Assembly of North Carolina, 2017 Legislative Session, Senate Floor, Senate Bill 691, second reading, and the date is Friday, August 25th, 2017. Do you see that?
Yes.
I'd ask you to turn to a discussion that you had on page 15.
Okay.
And I'm looking at the paragraph between lines 10 and 22.
Okay.
Could you read that paragraph, and then I'll have a question for you at the end?
Sure. Starting on line 10. Again, I have not done a total analysis of whether or not you've got a political gerrymander. But as I told you in the committee yesterday, I think the creation of District 16 as a competitive district, and it looks like a Democratic-leaning district, cures the foundation on which one would probably bring a political gerrymander claim. But the map still has high numbers of Democrats in a district and Republicans in a district, separate districts, and the way that the map is drawn has 2 strong Democrat, 2 strong Republican, and it looks like a competitive-leaning Democratic district.
So at the time that you delivered this statement on the floor of the Senate, and that you believed these districts had 2 strong Democrat districts, 2 strong Republican districts, and a competitive-leaning Democratic district, could you name which districts those are?
It would have been 14, 15, and 16. 16 was a new district, it wasn't new because Wake County picked up 5 districts after the last census. But there was a vacancy because one of the senators was leaving, the one who represented part of Wake County and all of Franklin County. And so the effort was to take one of the sitting senators from Raleigh, the Republican sitting senator, move him into that district that goes up in Franklin County, drawing a line basically from downtown Raleigh, snaking through North Raleigh, then into Franklin County. And just looking at it, because I've looked at these things for 30-plus years, it looked like that was going to be a Republican district, given the kinds of precincts that were in it, and it was being represented by a Republican in 2016. The new District 16 that would not have an incumbent in it was drawn across West Raleigh and Briar Creek, new areas in the city that had tended to vote Democratic over the last 2 or 3 elections. That's why I said it looks to be a Democratic leaning district. And it was designed to be a Democratic district.
And now in the election in 2018, Democrats won 4 out of these 5 seats, correct?
That's correct.
Okay. Democrats captured the 2 strong Democratic seats, right? And is that a yes?
Yes, I'm
Pardon
sorry.
me?
Yes.
Okay. And Democrats won the competitive leaning Democratic district?
Yes.
Is that right? And they even won one of the districts you deemed a strong Republican district, isn't that right?
Democrats won 4 out of the 5 districts in Wake County, 3 of them by greater than 62%. And in fact, I think maybe 2 of them with greater percentages than I won mine because they had turned so Democratic.
So
the other one was the new district that performed 66% Democratic, and the 4th one that was one I said was a 49% Democratic district, just barely 50% Republican performance. And he won it by 2,700 votes.
Okay. So let's look briefly at the numbers, and again, Senator, bear with me. I'll try to ask very precise yes or no questions so we can keep moving. I'm now looking at LDTX 49. This is the last page in your binder. These are the 2018 official general election results statewide, and this is for the Senate. I'd ask you to turn to page 3 and just confirm my read of the election results.
Page 3?
Correct. And on page 3 of LDTX 49, I see that the state reported in Senate District 14 that Senator Dan Blue garnered 71.36% of the vote in District 14. Do you see that?
That's correct.
Okay. And I see in District 15 that the Democrat garnered 73.1% of the vote. Do you see that? And in Senate District 16, I see the Democrat garnered 65.28% of the vote. Do you see that?
That's the new district that I said was tending to be Democratic.
Okay. And then one of the districts that you had described as being a strong Republican district, Senate District 17, the Democrat won there with a percentage of 50.6%. Do you see that?
That's right.
Okay. And then in the second district that you had defined as being a strong Republican Senate district, I see there that the Republican only garnered 49.9% of the vote. Do you see that?
That's correct.
And
the independent got almost 3%, or the libertarian.
Okay. And so it looks like the Republican in the strong Republican Senate District 18 only had about a 2.5% margin of victory. Would you agree with that?
I will agree with that.
Okay. And now I noticed that you were responsible for drawing districts 14 and 15 through your amendments, and both of those districts garnered over 70% Democratic vote. Isn't that right?
Looking at the 2 districts separate from the rest of the map in Wake County, they would have done that if everything had stayed the same. The outline and contours of those 2 districts we could not change. The interior of them we could change, and I was changing them to try to keep communities that had been closely working together on various things in the same districts. For example, using the belt line as a dividing place with some of these districts, or using in Wake County, say Rock Quarry Road beyond the belt line, put all of that in one district, but keep the rest of it in another district, because they tend to relate to each other. You know, so the high school and various other things within that geographical area.
Now, for the record, you did not think that the Senate districts in Wake County, as drawn in 2017, were a partisan gerrymander, did you?
In looking at it, if you had drawn another Democratic district, the county over the decade went to about a 60% Democratic performing county. And so if in fact there were, you said partisan gerrymander.
Correct, it's
Yeah.
a part, and it is a yes or no question. I'm
Yeah.
sorry to press you, Senator, out of respect, I don't mean to, but my question was, you did not think that the Senate districts in Wake County, as drawn in 2017, were a partisan gerrymander, right?
Based on the fact that a new district was created, that was a Democratic district, there would be 3 Democratic districts, 2 Republican districts. That's hard to argue that that would have been a partisan gerrymander unless it had been possible to draw 4 or 5 Democratic districts, and nobody was trying to do that. Or draw more Republican districts. Nobody could do that in Wake County.
So is that a yes?
Not really. It's a yes with a qualification.
I
Try to
see.
explain to you why.
Well, I
reached
have a
that conclusion.
few follow-up questions for you. You thought that your Second Amendment cured the foundation on which one would bring a political gerrymander claim, isn't that right?
That's correct.
Okay. You also thought that one couldn't sustain that there's a political gerrymander specifically in Wake County, right?
Given the way the districts were drawn and a new district was created and the close margins of the 2 Republican districts, no, I didn't think that a political gerrymander just isolated on Wake County would, even under the criteria present then, would be sustained.
Okay, now I'd like to spend the last portion of my examination looking at these 2 maps.
Okay.
So we'll return to these maps that are located at LDTX 37-4, which was your first amendment, which was adopted, and LDTX 38, which was your second amendment, which was also adopted. Now,
Okay.
pardon. Okay.
Yeah, I got you.
Now, Senator Blue, the maps look very similar, but there are some differences apparent to the naked eye. I'd like to walk through those with you. It
Okay.
appears that there were changes made between your first amendment and your second amendment to the western border of Senate District 14. This is the orange district, and you can follow along the western border where it touches on districts 15 and 17. Can you see some of the changes between what you drew in LDTX 37 and what you drew in LDTX 38?
Quite honestly, you have both of them side by side that
Yes,
can
we
put up?
do. We do.
Okay. I know what the changes were, but I don't necessarily see it in the map.
I can
Okay, so
appreciate
this
it.
is-
Here you go. Does that help you, Senator, the
Yeah.
side-by-side?
Yeah, I can look at that a little bit better. Okay, I do see the
Okay,
changes,
you see the changes along the western border of 14?
especially in the southwestern portion of it.
Okay. And it looks like you changed District 15 in the Second Amendment so that it would move eastward. Is that a fair description?
That's a fair description.
Okay. And it looks like, comparing the two, that you changed District 14 by having it move westward, a little westward in the Second Amendment. Do you see that? Okay.
I see that.
Okay. And now, the way you drew District 15 in your First Amendment includes a sort of appendage to the north. Do you see that?
looks like an arm sticking up to the north of District 15.
What,
The light blue.
the extreme northern part of that district?
Yes.
Or the western?
So looking at District 15, it looks like there's an eastern tall appendage that reaches north. Do you see that?
Okay, not the piece that looks like Michigan, on the right side, straight north.
The right side straight north, that's
I
right.
see that, yeah.
Okay. Okay. So that was drawn in your amendment, number 1. I'm looking at how that particular appendage changes in your amendment number 2. Specifically, it looks as though you narrowed that appendage. There's almost a choke point midway up that northern appendage in your second amendment to District 15.
Yeah, and 14 is moving further north.
Okay.
That's what's happening, and I will tell you why that's like that if you want to know. Why that is like that is I indicated that we were moving some of the African American voters out of 14 in case there were concerns about a racial gerrymander. But while moving them, we realized that there needed to also be sort of a continuity of interest among the communities that were being moved. And the ones that were being moved weren't really in an integral part, say in the downtown area. 2 blocks from here, Oakwood. If we were going to move Oakwood from District 15 to District 14, it introduced more white voters into District 14. And so if we were going to move African Americans from 14, then you had to pick up more non-African American voters. And in order to do that, you needed to go into predominantly white areas. And so you'll find the movement up into North Raleigh of 14 against 15. 14 is getting wider, 15 is getting narrower, and you're using whole precincts, and you're running straight up the Six Forks Road or the Falls of the Neuse corridor. You're not splitting precincts, you're not going across. So that's why you'll sense it getting a little narrow. But you change the makeup of those 2 districts from one that's low 30s in African American population, the other in the high 30s, to basically the same percentage of African American population in both of them. Okay. So that's what's happening, and you'll see that happening also sort of in the middle along the Belt Line and Rock Quarry Road and stuff. You're moving African Americans out in order to not have an overpopulation in District 14, consequently violating the Voting Rights Act.
Well, let me focus on this specific choke point for a moment. Okay. I think it may be helpful if we all focus on LDTX 3.8 on page 2. And if we can zoom in to that, what I'm describing as the choke point. So I appreciate the description you just gave, Senator Blue, and here's why. It confirms, but let me know if you agree with me, that you did not draw this choke point with a discriminatory partisan intent. Would you agree?
I agree. And the other thing, I knew that we couldn't go into the darker area, that blue, to clean all of the edges, because that was the district that was represented by a Republican incumbent. And the deal that we had made, or the understanding was, I could change within 14 and 15 because those were 2 Democratic districts, but could not cross these other district lines either. This must be 17, but couldn't go into 17 or 18.
And now, Senator Blue, you have many full-time jobs, so you'll be forgiven if the answer is no to this question. Have you had an opportunity to study plaintiff's amended complaint in this matter?
No. I know what the general outlines are, but I was not in for late night reading of 60-page, 80-page complaints.
Well, fair enough. We have had the opportunity to do that on your behalf. And I would like to bring up plaintiff's amended complaint because plaintiffs spent 3 pages in their amended complaint addressing the choke point that you and I just discussed. And I'd like to look at those pages now and then ask you a few questions.
Okay, sure.
We'll start with page 55 of the amended complaint. So I'll start on page 55. And Senator, I just want to show you where they've shown them in the complaints, and then I'll ask you a question. So we start with page 55. We have a photograph of this area. The choke point is depicted at the bottom of the photograph as a pink area between a yellow District 14 and a blue District 18. And on this page, plaintiffs claim the General Assembly created a tentacle for Senate District 15 that grabs North Raleigh's Democratic voters. The General Assembly created this tentacle in Senate District 15 via a narrow passageway containing no more than a Costco. Do you see that?
Oh, I'm sorry. Yeah, that's what it says. I'm sorry. I was looking at the map.
Oh,
I
pardon me.
apologize.
If you need more time. you
No,
can-
I'm good.
Okay.
I'm good.
Page 56, plaintiffs pointed out on a map calling it the Senate District 15 Costco Passageway. Could we turn to page 56? And finally, on page 57, plaintiffs again raised this issue of the Costco passageway in a closer photograph of this choke point I was discussing with you earlier. Do you see that?
Yeah, I'm looking at the photograph now.
Now, plaintiffs in their complaint suggested that this so-called Costco passageway was evidence of a partisan gerrymander. Would you agree with them?
I don't know the full context. As I've explained, this is what I was dealing with. We had an incumbent who lived inside the Beltline, near Carolina Country Club, or in that territory. And they had to get him up through there to get him into Franklin County. If you will look down at 14 is blue, I take it. And yellow is, 14 is yellow and 15 is blue. And the other one, the incumbent who lives inside the Raleigh Beltline, is trying to get through there without us, I guess, infringing on him. I knew I could not go over into that territory. And that's why if there's a hook on it, I drew it because I couldn't go any further, because they had to get him out of there into those other, into Franklin County.
You were the person responsible for this so-called Costco passageway. Were plaintiffs wrong in assuming that this was evidence of a partisan gerrymander?
I don't know that am I responsible for the Costco passageway? I don't know. And I take it that Costco is the only thing in there, up Six Forks Road. And I'm trying to think, and using the map earlier, whether I had any bigger portion of Six Forks Road. But the effort was to get 15 by your Johnny Mack, by the senator who was inside the Beltline that they were trying to protect. But to mix together my district and Senate District 15. And so whatever the configuration is that happened when we blended those two districts together was not intended to be any kind of gerrymander at all. It was intended to move voters from one district to the other to address the question of an overpopulation by design of African Americans in a district in Wake County when the need for that or the justification for it had not been shown through the studies.
Senator Blue, I really appreciate your testimony today. Thank you for answering my questions.
Sure.
Your Honors, at this point, I have concluded my examination. I would move to admit the following exhibits. Okay, thank you. That's all.
All right, so no admissions at this time? That's fine. All right. Very good. Intervening defendants, any questions? Yes, sir, Mr. Branch.
Good afternoon, Senator.
Howdy, how are you doing?
I promise I will keep this very short. At the end of Mr. Spee's questioning, I believe you testified that it would take 55% vote share for the Democrats to win a majority of the General Assembly. Is that correct?
That's correct.
And I think you characterized that as unheard of.
It's tough to get 55%. I don't think we've had very many statewide folk getting 55% of the vote lately.
And I believe you characterized it also, the 55% threshold, as a tsunami.
It would take just about a tsunami to make that happen in modern-day North Carolina.
Do you remember the last time one of the two major parties received 55% or greater vote share in the either house of the General Assembly races?
I mean, if you got 70 or 80 members of the same political party, you probably crossed that threshold. So that may have been in the House, maybe in the 90s. I don't know. That's all speculation.
Fair enough. So it would surprise you to learn that in 2010, the Republican vote share for both the House and the Senate was between 59 and 60%.
That wouldn't surprise me. It was a tsunami.
And it would surprise you to learn that in 2008, the Democrat vote share for the House was 55.18%.
It may have been. Again, I haven't studied it, but it may have been because of the nature of the campaign in 2008. You probably had a lot of overperforming Democratic districts because of the Obama presence on the ballot.
Fair enough. Thank you. That's all.
Thank you, Mr. Branch. For the state? Thank you, sir. Redirect, Mr. Spees.
If we could pull page 54 of the amended complaint back up and put it on the screen, just one question about that. Senator, a couple of questions about this map. Did I hear you testify that District 17 and 18 could not be changed?
That's correct.
And they could not be changed because those are the two districts that gave the Republicans a chance at a victory in Wake County.
That's correct.
And looking specifically at 18, the purple tentacle running from the main body of 18 down into Raleigh near the Carolina Country Club, you didn't draw that, did you?
No.
That was a tentacle that could not be changed because it would have destroyed the Republican opportunity to win that district.
Yeah, the understanding that I had was that I could amend freely within the two Democratic districts inside the core of the city, districts 14 and 15, and that's what I was doing to make sure that we didn't have a racial gerrymander.
And Senator Blue, let's go back just a minute to Mr. Hoffler. You never got a chance to meet with Mr. Hoffler to talk about the map.
No, and in fact, last time I saw Mr. Hoffler was in this courtroom. I think it was this courtroom when this case, similar case, was before this panel back in 2012 or 13. I talked to him then, but no, I've not talked to him about anything since then.
And you didn't get an opportunity to observe Mr. Hoffler applying the directions the legislature gave him to draw the maps, did you?
I did, and he did it quite well.
Okay. But you weren't physically with him watching him do it.
No.
And all you could look at was the result.
I knew what the desired results were, and he performed well so that he could preserve the supermajority that they gained in 2010.
And he missed that by one.
Missed it by one. Perfect storm helped us, help him miss it by one.
Thanks, Senator.
All right, we'll take a 15-minute recess and we'll resume at 4 o'clock.
Here, for some recess, 15 minutes.
Mr. Spees, further evidence for the plaintiffs?
Yes, Your Honors, the plaintiffs would call Representative Meyer to the stand.
Your Honor, if I may bring one thing to the attention of the court, this may be a good time to mention this. The parties have an agreement regarding disclosing to each other the order of witnesses and that sort of thing the night before. Representative Meyer is out of order for the plaintiffs, but we're certainly happy to accommodate that today.
And thank you very much. I appreciate that.
Please place your left hand on the Bible and raise your right. Do you solemnly swear that the testimony you're about to give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Good afternoon, Representative Meyer. Would you state your name for the record?
Good afternoon. My name is Greg Meyer.
And would you tell the judges about your background?
Certainly. Your Honors, I was born in Cleveland, Ohio, moved to North Carolina in 1998 after attending the College of Worcester for undergraduate and then the University of Chicago for a graduate degree in social work. I worked in North Carolina's public schools for 16 years before entering the legislature in 2013.
And would you describe for the court briefly your tenure in the legislature?
I was appointed to a vacant seat in 2013 after Senator Valerie Foushee was appointed into the Senate. I've been elected and reelected to the office in 2014, 16, and 18. And you were a member of the legislature in 2017 when the House map was redrawn, correct? Yes, sir. Did you tell the court how you participated in that map redrawing process? I was a member of the House of Representatives, and I was present during all of the House floor sessions upon which we debated and voted on the bill and the maps. Representative Meyer, do you recall attending the August 28, 2017 session of the House? I do. Would you turn to Plaintiff's Exhibit 590, which is the first tab in your witness notebook, and I would like to ask you a couple of questions about things that happened on August 28. First, what was the purpose of the August 28 meeting of the House? I believe that was the first time that Representative Lewis presented the proposed maps to the body. And do you recall Representative Lewis telling the members of the House who had drawn that map? I do. Okay. And who was that? Dr. Thomas Hoffler. Okay. And do you recall Representative Lewis telling the members of the House what criteria and data that he had told Hoffler to use in drawing the map? I do. And do you recall that one of the criteria was to use political data for political considerations? Yes. Okay. And during the course of that meeting, did Representative Lewis tell the members of the committee why he had hired Mr. Hoffler to draw the map? Yes, he did. He told us that Dr. Hoffler was especially fluent in interpreting the wishes of legislators and turning it into a map using the program that was being used. I would direct your attention, Representative Meyer, to page 36 of Exhibit 63, specifically lines 14 to 19, and ask you if you would read those lines into the record. Yes, sir. Representative Lewis speaking. No, I don't think the 2011 plan would have had anything to do with it. I think it was more that we agreed that Maptitude was sort of the industry standard used nationwide, and he was just very fluent in being able to help legislators translate their desires to the Maptitude program. Who is he in that statement? Dr. Thomas Hoffler. Okay. Now, let me ask you, Representative Meyer, to turn to Exhibit 591, which is the next entry in your notebook, and ask you if you recognize that as the, quote, stat pack for the House map drawn by Mr. Hoffler. Yes, sir, it is the stat pack. And have you carefully reviewed that document? Yes, I have. And was that information in front of the legislature when it was considering the House bill in 2017? Yes, sir. It was provided to all members of the legislature and the public in electronic copy.
And could you describe to the court briefly what use is made of this kind of political data when it's in front of the legislature when considering a map?
Well, the stat pack shows you how 10 statewide elections would have performed within each of 120 House districts. So these statistics are used to predict what the likely partisan result would have been for all 120 House districts in previous elections.
And to your knowledge, did Dr. Hoffler select these 10 elections to analyze for that purpose?
To my knowledge, Dr. Hoffler worked with the Republican majority to identify these 10 elections.
And did you and the members of the Democratic caucus in the House examine Exhibit 591 to determine what you expected the political impact of the 2017 map to be?
Yes, we did, and we found that under all 10 elections, it was most likely that Republicans would maintain supermajority control of the North Carolina House of Representatives.
And let's switch now to the 2018 elections. What was your role in the 2018 elections process?
I served as the recruitment chair for the House Democratic Caucus and later as the finance chair.
And what did you think the Democratic Party's prospects were at the 2018 elections under this new plan?
Running under gerrymandered maps is difficult. We were hopeful that we would be able to break the supermajority and tried to recruit as many people as possible so that we could take advantage of any tide that came our way.
And why did you think there was a chance to break the supermajority?
We believed that it was a blue moon election, which happens once every 12 years in North Carolina, where there is no gubernatorial, Senate, or presidential election, which would bring additional attention and opportunity to state legislative races, as well as we felt that after the 2016 election, it would possibly be a strong Democratic performance year because it is traditional in off-year elections for the party that is in opposition to the presidency to have a good off-year election, so it should have been a good year for Democrats. The largest restricting factor we felt was the composition of the maps.
And was it important to overcome the supermajority?
Yes, sir. It's no fun to be in the minority in the legislature.
Did you succeed in breaking the supermajority?
We did in the North Carolina House, yes.
And how were you able to do that?
We were able to have a gain of 10 seats in the North Carolina House, bringing us from 45 representatives previously to 55 in the current session. We did that by essentially we ran the largest number of candidates we'd ever fielded and the most well-funded campaign operation for legislative races in the history of North Carolina.
With all this money, with all these efforts, with all these things on your side, were you able to win a majority?
We were not able to win the majority.
And could you tell the court why?
To win the majority in the North Carolina House, we would have had to overcome significant structural disadvantage based on the way the districts are drawn that we were able to predict from looking at previous election performance, such as what's in the stat pack. And although Democrats had a strong year nationally and in North Carolina and were able to pick up seats and break the supermajority, there was not the type of wave election that took us to the majority.
Okay. And let's talk briefly about another topic. What are support scores?
Support scores are a purchased score that is assigned to each voter in the state and that we use to determine which voters we should target for paid communications such as digital or mail, or for individual communications such as canvassing and knocking on voters' doors.
And do you know what information, so there's a support score for every North Carolina voter?
There is.
And do you know the kinds of information that go into compiling this support score?
It's proprietary data from the company that we purchased the scores from, but my understanding is that it's a combination of consumer data as well as geographic and other factors that give you a sense of the likelihood someone is going to support a Democratic candidate. It is an imprecise measure, and we almost always use it in conjunction with other measures, such as a turnout score, which tells you how likely someone is to actually vote, which would be important for determining whether you should talk to them or not.
And are these support scores used, in your experience, exclusively for a purpose of identifying where and how you should campaign?
Yes, sir.
Okay. Now, have you ever made any use of aggregated support scores?
No, sir. Aggregated support scores wouldn't be all that helpful because individual support scores can be misleading. For instance, if you had two white women who lived inside the Beltline, drove Toyota Priuses, listened to NPR, had subscriptions to the New York Times, they would both have relatively similar support scores, but one of them could be a guaranteed 100% Democratic voter and the other one could be a guaranteed 100% Republican voter. They're imprecise measures. And then if you aggregate imprecise measures like that, they tend to get less and less precise in the aggregate.
And when the Democratic Party is interested in knowing how a map or a district within a map will perform politically, what does the Democratic Party look at?
We look at an index of previous performance. Generally, we call it the Democratic Performance Index. It's not necessarily a proprietary number. It's not actually all that hard to figure out. It's essentially an average of how all campaigns in that district have done previously. The stat pack provides you a reasonable estimation of the same information that we would use. Sometimes we even just pick a single previous performance to use as our benchmark.
And is the data in Plaintiff's Exhibit 591, the stat pack, an example of a partisan impact index?
Yes, sir.
I may be repeating myself, but pardon me. Are support scores ever used to predict election results in your experience?
No, sir.
And again, why is that the case?
Well, because they're not reliable in the aggregate and not even necessarily 100% reliable in the individual, they don't tell us the likelihood of who is of what an election could be. We have to look at things like who's actually going to vote, and it doesn't tell you whether that person is going to vote or not. And there are ways that support scores can get skewed dramatically from what an actual performance in a district would be. It's a very different type of data than we use to measure electability performance.
Thank you, Representative Mark.
Good afternoon. Good to see you again. Mark Braden with the Legislative Defendants. Us folks from Ohio have to stick together.
Very good to see you again, Mr. Braden.
Good to see you. So you were first appointed to the North Carolina House in 2013?
Yes, sir.
So I'm correct to say that you've got no experience prior to this one redistricting on the prior redistricting process in the state of North Carolina.
That is true.
But you probably know enough history of North Carolina to know that the Democrats have been in charge of the redistricting process since the end of Reconstruction, correct?
I understand that to be true, yes.
Yeah. And so, am I correct that you actively campaigned for an independent redistricting process throughout your political career?
Yes, I have.
Okay. So you're in opposition to the present process?
Yes, sir.
But do you believe the present process is fundamentally different than the way that the Democrat Party conducted redistricting over those earlier decades?
No, sir. I believe that the process is similar in terms of taking advantage of partisan gerrymandering, and I am opposed to the process as used by either party.
Okay. I don't know if you were present for Senator Blue's testimony, but I'm going to ask you some of the same basic questions. In your role as a member of the legislature, obviously part of it's legislation and public policy, but do you also have an ombudsman role?
Yes, sir. We are responsible for trying to work with constituents on a variety of issues.
And do you view constituent service as nonpartisan activity?
Yes, sir.
So it doesn't matter to you whether a particular voter who needs, as an example, his retirement check from the state system is a Republican or Democrat?
Correct.
You would never check that?
Correct.
And you represent a district that has both Republican and Democratic voters in it, correct?
Yes, sir.
And do you believe you represent the all individuals living in that district?
I do the best that I can. I'm sure I don't make them all happy at all times.
None of us are successful at doing that I'm aware of. So you represent everyone in the district as best you can.
Yes, sir.
Okay. So I'd like to talk a little bit about what you actually did in the election. So, am I correct that you were the recruitment chairman for the Democrat House campaigns?
Yes, sir.
And were you successful at that?
We were successful in recruiting a candidate for every district to run for every district in the North Carolina House.
Can anyone remember that ever happening before?
Not that anyone has told me, sir.
And of course, this recruitment happened after the adoption of the 2017 plan, correct?
Yes, sir.
Okay. And I also understood that maybe you had another title. You were the finance director at the back end for the legislative
I was one
House
of the
campaign?
co-chairs for the finance committee, yes, sir.
So let me talk about recruitment. Were the Republicans as successful recruiting as you were?
They were very close, sir. They got within one.
Okay. And am I safe to assume that you can't win a seat you don't have a candidate for?
Correct.
So all the seats, with the exception of one, were contested in the state, correct?
Yes, sir.
Okay. So let's go to your fundraising. Am I correct that in 2018, the North Carolina Democratic Party raised the most money it's ever for legislative campaigns in history?
I believe that that's correct.
Does 15.6 million sound about right?
I actually don't know the total number. I'm sorry.
Do you know whether it's double or triple the amount that was raised in 2014?
I don't know. I'm sure that you could compare to State Board of Elections records.
Do you know how that compares with the money that the Republicans raised?
I believe it was more money than the Republicans raised.
Okay. And were there additional funding sources for Democratic legislative candidates in the last election from outside the state?
There are always independent expenditure groups that are involved with elections in the state on both sides or sometimes multiple sides of any election.
Sure. Do you remember a group called the Democratic Legislative Coordinating Committee?
Yes, sir.
Is that part of the DNC?
I believe it is an independent organization that falls under the larger Democratic canopy. I don't believe, to the best of my knowledge, that the DLCC is a subsidiary of the DNC.
Does it exist to help elect Democrat candidates to state legislative bodies?
Yes, sir.
So it's safe to, so its goal is to elect Democrats to North Carolina House, the South Carolina Senate, all across the country would have that position.
Yes, sir.
Do you know how to decide where they spend their money, how they target it?
Do I know how they decide?
Yes.
No, sir. Not in 2018. I don't know how they decided that. I mean, I guess I would assume that they spend their money where they think they have the best chance of gaining a majority. That would be my assumption.
And did they spend a lot of money in North Carolina in the last cycle?
They did not spend a lot of money in North Carolina.
What would you consider a lot of money?
I would consider a lot of money by any single organization to be $1 million or above.
Mm-hmm. And this organization did not spend $1 million.
I do not believe that they spent $1 million through direct contributions to the North Carolina Democratic House Caucus or to North Carolina Democratic House campaign committees, individual committees.
Did they make independent expenditures?
I don't know, sir. Independent expenditures aren't always publicly disclosed.
So is this organization much like the Republican State Leadership Committee?
I think it would be the equivalent.
Yeah, and so their goals would be similar to simply mirror images of each other?
Yes, sir.
And did I also remember from our deposition that there was a number of organizations conducting training for Democratic candidates across the state?
Yes, sir.
Lead North Carolina was that one?
Yes, sir.
And a pipeline project, was that to get state and local candidates, Democratic state and local candidates?
Pipeline project was a project of the North Carolina Democratic Party.
And the Institute for Political Leadership?
That's an independent organization that trains candidates from both parties.
Oh, from both parties, okay.
Yes, sir.
And am I correct that you consistently made the argument in your fundraising and recruiting that the Democrats could take over the North Carolina House?
That we would like to take over the North Carolina House, and we would do our best to try to do so, yes, sir.
My exact question was, am I correct that you consistently made the argument that the Democrats could take over the North Carolina House? Do you remember that question in your deposition?
I don't remember the specific answer I gave you in the deposition.
Sure. Why don't we, if we can pull up the deposition testimony. I think this would be page 36. And if you would, I'll read you the question and maybe you can read the answer starting in line 21. During this process, were you expressing the opinion that you thought the Democrats could take over the North Carolina House? And your answer was?
Are you asking me to read on line 24?
24.
Yes, sir. I consistently made the argument. Without finishing that sentence, I was interrupted by my counsel.
Sure. And so the rest of your answer comes over on the next page. We can go through it, but do you believe the answer on lines 11 through 19 are inconsistent with consistently making the argument?
Permit me a second just to reread it.
Sure.
Yes, sir. I believe it's consistent with the case that, with your question, that we made the case that that 2018 would be the best opportunity we had since 2011 to win a Democratic majority, but that the biggest stumbling block for reaching the majority continued to be the districts even after the 2017 maps were enacted.
So let me talk a little bit about your recruitment efforts. Were you able to recruit a diverse group of candidates?
Yes, sir, I would say so.
Were you able to recruit Hispanic candidates?
We did have one Hispanic candidate running for North Carolina House.
And women candidates?
Yes, sir.
And African American candidates?
Yes, sir.
So let me talk a little bit about how successful your recruited candidates were. How many seats did you pick up in the election?
10 seats.
10 seats. And were they principally open seats? Or were they seats where you defeated incumbent Republicans?
It was a combination of the two, but there were a number of seats where we defeated incumbents.
And does incumbency traditionally have a big advantage to be an incumbent member generally?
Yes, sir.
And how many races did you spend money on? Do you remember?
I think that the House Democratic Caucus and the State Democratic Party spent money on supporting probably 20 to 30 races and with any significant expenditure.
So somewhere between 20 and 30. And I assume you spent money on races that you thought were competitive?
Yes, sir.
And how would you define a competitive race?
Generally, we measured competitive in the 2018 election cycle by looking at any race where the district was drawn, the way the district was drawn, that Governor Cooper had performed with 47% of the vote or higher for that district. I think most of the time we believed that Governor Cooper's performance was the best benchmark for determining what we thought likely performance could be as a baseline. And there were other races that we did spend money on that went below that for the reason of hoping we could do a little bit better.
Mm-hmm. Am I safe to assume you generally didn't spend money in races you thought had no opportunity of the Democrat candidate winning?
Correct.
I'd like to go to the Legislative Defendants Exhibit 007, which is basically that. I think we've seen this before. This is the House and Senate plan criteria. I am going to ask you some questions about the criteria and see whether your opposition or support for the various criteria that were adopted by the House and Senate in 2017. The first one is equal population. So that criteria provides, and I'll just read it real quickly, that the committee shall use the 2010 federal decennial census data as a sole basis for drawing legislative districts in 2017 House and Senate. The numbers of persons in each legislative district shall comply with a plus or minus 5% population deviation standard established by Stevenson. Do you have any disagreement with that provision?
I do not have a disagreement with that.
And do you believe the adopted plan in 17 complied with it?
Yes, sir.
Okay. And the second one, contiguous. Legislative districts shall be comprised of contiguous territory. Continuity by water is sufficient. We certainly need that with the Outer Banks, I'm sure, but do you have any dispute with that provision, that criteria?
No, sir.
And do you have any reason to dispute that the present plan complies with it?
I believe it complies.
Yeah. Counting groupings. There's a lengthy set of citations here, so I won't go through all of them, but I'll just briefly summarize it by saying that the committee shall draw legislative districts within the county groupings as required by a series of the Stevenson cases. And within the county groupings, county lines shall not be transversed except as authorized by Stevenson 1, 2, and 3, 1 and 2, and Dickinson 1 and 2. Do you have any disagreement with the county grouping provision?
I do not have a disagreement with that provision.
Okay. And do you know what percentage of the state, the House districts, the state population is assigned automatically by that provision?
I do not know that number.
Would 63% maybe sound about right?
Sure. I wouldn't have any reason to dispute it.
So if that's correct, then 63% of the total population of the state wouldn't be subject to any way of gerrymandering because it's set by statute, set by the Constitution.
Well, I believe that you could still have gerrymandering within a county grouping even after the county grouping was made according to the guidelines.
Yeah, but I believe the 63% is based upon whole county and county groupings that can't be varied, but that's a legitimate point. Let me ask just simply the question about county groupings. Do you think that impedes the ability to partisanly gerrymander?
Do I believe that county groupings impede the ability to partisan gerrymander? Yes, I think that I'm not a lawyer, sir, but my guess is that the reason why you have all those findings there is because in one way or another, sticking to county groupings is seen to impede some form of gerrymandering.
Let me go to the next one. Fewer split precincts. The committee shall make reasonable efforts to draw legislative districts in 2017 House and Senate plan that split fewer precincts than the current legislative plan. Do you know whether the 2017 plan splits fewer VTDs than the prior plan?
It is my understanding that it did split fewer precincts.
Okay. The next one is municipal boundaries. And I assume you have no problem with the policy underlying not splitting precincts.
Agreed, sir.
Yeah. And in fact, I think you actually, in your prior district, you had a split precinct you were unhappy with, as
Correct.
I remember.
That's right.
Yeah. Municipal boundaries. The committee shall consider municipal boundaries when drawing legislative districts in the 2017 plan. House and Senate plan. Does that seem like an appropriate public policy?
I think the word may is the important statement here, and that, yes, it can make sense to consider political and geographic boundaries such as municipal boundaries when drawing counts. Yep.
Now I think we're going to get to one that I remember you didn't agree with, which is incumbency protection. Reasonable efforts and political considerations may be used to avoid pairing incumbents of the House and Senate with another incumbent legislative district drawn in 2017 House and Senate plan. The committee may make reasonable efforts to ensure that voters have a reasonable opportunity to elect non-paired incumbents of either party to a district in the 2017 House and Senate plan. Is I correct that you did not support that criteria?
Yes, sir. I'm opposed to this criteria. I believe that this is the criteria that allows for politicians to pick their voters rather than for voters to pick their politicians.
Okay. Do you know whether the 2017 plan paired any Democrat incumbent House members?
I do not believe that it did pair any.
Do you know how many Republican legislative members were paired by the plan?
I do not believe that it paired any against each other.
You don't think there were any members that were paired in the legislative plans, Republican members?
Actually, I believe there may have been one in Cabarrus County where one of the members ended up running for Senate instead. There could have been others that I don't remember. I believe that there was not any result of incumbent members running against one another in a primary.
If you were to pair two incumbent members when you draw the district, that means you would be making a decision that one of them would be not coming back to the legislature, correct?
Presumably, unless they ran for the other chamber or moved to another district.
Okay. They would not be coming back as a member of the House. If you paired them, one of the two members, if you paired two members, one of them would not be able to return to the House of Representatives.
Unless they move to another district.
Unless they move to another district.
Yes, sir.
So when you did that action, to a large degree, the line drawer would be making a decision to effectively remove somebody from the House, correct?
I mean, that's one possible outcome of it, yes.
Yep. Do you... In your recruiting of candidates, since you were able to recruit them in every district, did you recruit candidates in geographic areas where the Democrats had not had candidates recently?
Yes, sir.
And what areas would those have been?
I mean, most of those areas were rural districts. There may have been a small number of urban or ex-urban districts where that was true.
So is it safe to say that the Democrat voters are more concentrated in urban areas than Republican voters?
I believe that that's true.
And that's reflective then in the fact that you had to go out and recruit harder in areas where you'd not traditionally had candidates in rural areas because Democratic support was weaker.
That's right.
Yeah. Do you remember last month that the legislature adopted changes in the House plan in Wake as recommended by the master?
Yes, sir.
And do you remember that it was proposed by the leadership of both the House Democrats and Republicans?
Yes, sir.
And do you know whether or not it passed unanimously?
I believe it did, sir.
So that was obviously an action that was a bipartisan action to make that change in the plan.
Yes, sir.
Just a just three specific candidates I want to ask you about. Do you remember who you recruited in House District 1?
Yes, sir.
And who was that?
Ron Wesson?
And is he one of your minority candidates?
Yes, sir.
African American?
Yes, sir.
And did he win that race?
He did not, sir.
Do you happen to know what the black voting age population in that district was?
I do not.
Safe to assume it was not a majority-minority district?
Yes, sir.
House District 12, do you remember who you recruited there?
Yes, sir.
And who was that?
That was an incumbent, I believe. It was Representative George Graham who was running.
And he ran against Chris Humphrey, a white Republican?
Yes, sir.
And did George Graham lose?
Yes, sir.
And do you know the black voting age population in that district?
I do not, sir.
Safe to assume it was not a majority black district.
That's my understanding.
House District 7, do you remember who you recruited there?
We had another incumbent running in House District 7, Representative Bobby Richardson.
And was Bobby Richardson an African American candidate?
Yes, sir.
And did Bobby Richardson win his race?
It's a she, sir.
Oh,
but,
she. My
she
apologies.
It's okay. She did not win her race.
And she lost to a white Republican woman, Lisa I recognize as Lisa Barnes.
Yes, sir.
Okay. Safe to assume you don't know the black voting age population?
I do not, sir.
But you don't believe it's a majority black district?
I do not believe so, sir.
I know you have a day job, so I'm going to let you go back in just a second here.
Got till 7 o'clock, sir.
I don't have it until 7 o'clock. There's three people on this bench here, I'm absolutely sure, aren't willing to be here until 7 o'clock. I just want to bring up real quickly some maps. This is a case about maps. And I'd like to bring up, if we could bring up this will be, you've seen this before and you're probably going to see it often. This is Legislative Defendants Exhibit 25, which is simply a color-coded map of the challenge districts. So real quickly, I just want to go through a handful of these. And these are the districts I understand, as much as I understand the complaint in this case. The ones that are colored, I understand to be the districts which the plaintiffs are claiming are partisan gerrymanders. So I'll make that representation to you. They'll get an opportunity to tell us whatever ones that they disagree with. But let's talk about a couple of them. If you look over, I'm sure you know where Asheville is.
Yes, sir.
It'd be right to say that House District 114 is Asheville.
Yes, sir.
And the county grouping would be 116, 114, and 115.
Yes,
correct? My understanding of the plaintiff's complaint is that that's a Republican gerrymander. Do the Republicans win any of those seats in the last election?
Not in 2018, sir.
Okay. So you couldn't redraw that district in any way that would elect more Democrats than are presently there, correct?
Correct.
So, in your opinion, why is it a gerrymander?
Well, I'm not the plaintiff's attorney in the case, sir.
Stable conclusion.
Why is it unfair to Democrats?
Why is it unfair to Democrats, sir? Well, in the way that it's drawn, Democrats are packed heavily into District 114. You could draw that map you could draw Buncombe County in any number of other ways to make Districts 115 and 116 easier to win for Democrats. I don't necessarily personally have a criteria for fairness there, but you could certainly draw it to make it easier.
So you could divide up the city of Asheville and put a little bit of Asheville in the other two districts?
Yes, sir.
But that would seem to run counter to keeping a municipality together, right?
Yes, it would.
If I could move to Mecklenburg, it would be cheaper than living in Washington. Well, maybe not anymore. It's booming these days, I guess. Looking at Mecklenburg, you know how many districts are there?
I believe there's 11 House districts in Mecklenburg County.
Yeah. And I'll represent to you that my understanding is that the plaintiffs take the position that that's a partisan gerrymander. The Republicans win any of those seats in the last election?
Not in 2018.
So the Democrats control every seat in Mecklenburg. Do you know what percentage of the vote the Republicans get countywide for House races?
No, sir.
So it's safe to assume, though, they're not getting a proportional representation since they must get some, right?
Not sure any of us are asking for proportional representation, sir.
We might have different views on that. So can you look at that map and point out something that you say is unfair to the Democratic Party and the Democrat Party voters?
I believe when you look at the stat pack, you can see that particularly districts 103 and 98 were drawn in a way to be as advantageous to Republican candidates as possible, and particularly in House District 103. If you look at the numbers of previous performance of Democrats in that district, it's an extremely difficult district for any Democrat to compete in and win, and in fact was the single closest election in the North Carolina House of Representatives in 2018, and required over $1 million in spending, an absurd amount of money for a Democrat to win.
Is then if I'm mischaracterizing your answer, don't be shy. The problem with that district is that it's too competitive for the Democrat candidate?
Well, I'm not sure there's such a thing as too competitive, sir.
So what's the problem with it being a hotly contested race? That sounds like what the Democrat candidate wanted, but it was hotly contested, so why is it unfair to the Democrats? It seems like that's a competitive district, and aren't competitive districts good?
My point on House District 103 is that in order to make that election competitive in result, we had to recruit the daughter of probably the most well-known political figure in the state, former Governor Jim Hunt, and her election had to be financed at a level that no previous House election had ever been financed in the history of state elections. And still she won by fewer than 100 votes. It took an extreme amount of work to overcome the significant gerrymander of the district.
So you say the district's gerrymandered?
I do believe that it's gerrymandered, yes.
I think we'll let you make that opinion, even though apparently it's not a lay opinion. But let me ask the question then, so the problem with it is that you had to recruit a good candidate for it?
The problem with it is that the structural makeup of the district, based on previous performance, makes it about as difficult as possible for a competitive election to happen as you could do in that portion of Mecklenburg County. It is skewed as far as possible towards the Republican side as compared to any other way that you might draw it in Mecklenburg County.
So, and this is District 103?
Yes, sir.
When I look at the map, it doesn't appear to be particularly unusual in shape. It seems to be basically geographically one area of the district. Am I wrong about that?
Sir, I know that the advocates like to make a big deal out of the shape of districts, but I believe the statistics behind voter performance in the district is a much better prediction of gerrymandering than the shape of the district.
Oh, so the earlier arguments we've heard about a Costco and arms, we should ignore that?
I'm telling you my personal opinion, sir.
Thank you very much.
Okay. I'm sorry.
Good afternoon, Representative. A couple of quick questions about the support scores. I believe you testified in response to questions from council earlier that you didn't think that the NCDP district level support scores were reliable predictors of electoral outcomes because they are an aggregate of support scores for all voters in each district. Is that an accurate characterization of what you said earlier?
Yes, sir. Can I explain in full?
Absolutely.
Would you allow me to refer to one of the exhibits that's been submitted to the court? Could I ask to have the court examine Exhibit 278?
Is that legislative defendants or plaintiffs 278?
It's a legislative defendants. I'm sorry.
Your Honors, this is the actual support scores that were previously designated as highly confidential. And
is there any objection to unsealing that exhibit?
No, Your Honor. We, in fact, have talked to the other side, and our agreement is they may be used at the court, but we have asked that after these court proceedings that they not distribute them elsewhere.
I'm sorry, that they not
distribute them elsewhere.
All right. That's fine. Well, this is an open proceeding, so that the scores, if they are introduced into evidence without objection and not under seal, then they become part of the public record.
That's correct.
All right, very good. Yes, sir.
May I proceed, sir?
It's on your screen.
Yes, sir.
Yes. Go ahead.
Your Honors, when I examined this exhibit from the legislative defendants, it didn't make any sense to me as a campaign strategy document, because what they're presenting to you here in the second column is an aggregate of the individual voter support scores for each legislative district. So if you look in House District 1 where it says 48.26, that would mean that on average, the average Democratic support score in that district would be 48.26. As I mentioned earlier, we don't use support scores to determine electability of a district because we don't believe that you can aggregate a score like this and get an accurate representation of electability in any specific district. In this district, District 1, Governor Cooper in 2016 got 45.6% of the vote, so it's not too far off of what the aggregate support score is. And our candidate there eventually got 46.9% of the vote. But I'd like to show you a couple other examples that don't fit as closely to what the aggregate support score is. If you would look at House District 68 on page 2, it suggests that the aggregate Democratic support score should be 50.8%. The defendants have it coded dark blue, meaning it is a likely Democratic win. But Governor Cooper actually only received 38.02% of the vote in that district. So that's 12 points lower than what they suggest the aggregate Democratic performance should be. And in fact, our candidate in that district who outperformed the governor by 3 points still only got 41.5% in that district. So that is a district that we did not at any point consider to be competitive in the 2018 election based on the previous data we'd seen, such as what's in the stat pack or polling available to us during the election cycle. There's a similar number in House District 83 where the defendants suggest that that district should be a 50.59% Democratic district. but the governor received actually 41.54% in that district. Our candidate significantly overperformed the governor and got 47.2% of the vote in that district, but still didn't come close to the 50.59% suggested by the defendants. In total, the defendants suggest in light blue here that there are 12 districts that they believe should be flippable according to using support scores if you use that as your index. And Democrats won 4 of those 12 seats in 2018. So that would mean that we lost 8 and won 4. Knowing that we previously let me say this. At the end of the document, the defendants suggest that if you tally these up with those competitive districts and the 2 that I showed you that they suggested should be Democratic, the Democrats should be able to win 65 seats total if we win all of the seats that they identify as competitive. If you start with the number 65, you subtract the 8 that we did not win out of the light blue categories. That takes you down to 57. If you subtract the 2 additional districts that I already pointed out to you were so far off by the support score index, that takes you down to 55, which was in fact the exact number of Democrats who were elected in the 2018 election.
All right, and just to summarize from the global level.
It's your belief that when you aggregate whether they're these measurements that comprise the support scores or survey responses, or if you have an aggregated collection of information, that aggregation may be more prone to error than the individual scores that comprise the aggregation, because you've got a collection of information measurements that may all have their own margin of error within them. Is that fair?
Yes, sir.
Okay. That's all I have.
Thank you.
Cross-examination, Mr. Speaks.
Just one additional question. Why are redistricting laws so important to our citizens?
Mr. Spees, redistricting laws set the rules for elections, and elections set the body who creates policy. Having served in the minority for my entire time in the legislature, I've had scant chance to make a significant legislative impact on behalf of my constituents. Given that I've been in a super minority for the first 3 terms, this year is actually the first time that I have ever felt that I have any ability to have significant leverage in the legislative process. And so therefore I feel that it is the maps that set the playing field, that creates the teams, that then sits down and tries to figure out what's best for the people of North Carolina. And when the maps are not fair, the people are not fairly represented.
And you think the starting line in that race ought to be at the same place for both parties, correct?
I do. I believe that we should have an independent redistricting process for the people of North Carolina.
No other questions, John?
Thank you.
Your Honor,
Yes.
if I might move into evidence, blue exhibits 601, 602, 603, 606, and 597, and Meyer exhibits 590 and 591. I believe those are the exhibits that those 2 witnesses talked about on direct.
No, Your Honor.
Mr. Grant.
No, Your Honor.
Mr. Tolchin.
No, Your Honor.
All right, they're admitted. All right, it's a few minutes before 5. Thank you, sir. You may step down. Can you give us a forecast of what you have for us?
So we have one more witness who we'd like to call today. He's a voter plaintiff. His direct will take a very short time. And my colleague John Robinson will then on Garrett.
Your Honor, may we inquire as to how long the cross may go, or would the court be okay if we did directly pick up the cross?
We're going to go as long as we reasonably can. If it looks like that it gets, we need to go into the next day, then we'll need to go into the next day.
All right, I just want to highlight the court that we don't want to be prejudiced in the length of the cross because we're at the end of the day.
You do what you need to do, Mr. Strack.
John Robinson from Marlin Porter Case Law.
Please remain standing. Place your solemnly swear that the testimony you're about to give this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Good afternoon, Mr. Miller. Could you please state your full name for the record?
Derek Ray Miller.
Mr. Miller, where do you live?
I live at 409 South 7th Street, Wilmington, North Carolina, 28401.
About how long have you lived there?
Approximately 10 years.
You said that you lived in Wilmington. Could you tell the court a little bit about the Wilmington area?
I would describe Wilmington as a beach town, a college town, and Wilmington together with its county, New Hanover County, I would describe as a purple area, a bellwether area, and a battleground state.
And Mr. Miller, what do you do for a living?
I teach German at the University of North Carolina, Wilmington.
Are you a plaintiff in this case?
I am.
And Mr. Miller, are you registered with a political party?
I'm a registered Democrat.
How long have you been a registered Democrat?
For over 20 years. For over 20 years. Oh.
Mr. Miller, how often do you vote?
Since at least 2008, I have voted at every opportunity, primaries, municipal elections, and every election that I've been able to.
Why do you make it a point to vote so regularly?
I think it's a moral obligation to participate in the democratic process to the extent that we are able to.
Have you been involved in democratic politics in the state of North Carolina?
I have volunteered for various campaigns, canvassing, phone banking. As the 2016 election approached, I became more active canvassing, and then in the wake of the 2016 election, I increased my participation. I became precinct chair of my precinct, which put me also on the county committee for the New Hanover County Democrats. I served a term in the North Carolina Democratic Party State Executive Council and other committee assignments and the like.
Are any of those positions paid?
No.
Why do you volunteer so much of your time to those democratic organizations?
I think on the whole, the Democratic Party and Democratic candidates best represent my views on matters of a host of matters and in totality, but in particular issues like education, environment, and so forth.
So Mr. Miller, I'd now like to talk a little bit about your state, Senate, and state House districts, starting with your state Senate district. Do you know the number of the state Senate district in which you live?
Senate District 8.
Do you know how long you've been in state Senate District 8?
I believe for approximately 10 years. Oh, no, excuse me. I became aware that I was in it in 2012.
Do you know who your state senator is?
Bill Rabin.
Is Mr. Rabin a Democrat or a Republican?
Republican.
Did you vote for Mr. Rabin?
I did not.
For whom did you vote?
David Sink, the Democrat.
And Mr. Miller, are you generally familiar with the current makeup and boundaries of Senate District 8?
Its general outline, yes.
So I'll put up on the screen for demonstrative purposes only Plaintiff's Exhibit 272. Mr. Miller, what does this appear to be?
This looks like a map of state Senate districts 8 and 9.
And could you identify on the map there, if you can, where approximately you live in Senate District 8?
Okay, I live in this small outcropping, which is known as the Wilmington Notch.
I think we have a close-up of that notch, which is Plaintiff's Exhibit 273, which I'll put up for demonstrative purposes only as well. And so Mr. Miller, again, where do you live on this map? No need to draw it on the exhibit.
It's in that notch. It comes up to the right of the numeral 8.
Now, Mr. Miller, you said that you've lived in that notch for approximately 10 years. Can you think of any reason other than gerrymandering why Senate District 8 would be drawn that way?
I cannot. To me, it appears arbitrary. I cannot.
Does that notch follow any political boundary that you're aware
of? None that I'm aware of. Again, like I can see across the line from my kitchen window. It's on the other side of the street. When I walk my dog like 3 times a day, I go in and out in between Sentence District 8 and 9 on our walk.
Does the notch follow any geographic boundary that you're aware of, such as a river, for example?
It crosses a river. It does not follow any geographic boundary that I can tell.
And I know that by placing you in Senate District 8, you're combined with Brunswick County. Do you consider Brunswick County to be part of your local community?
No, I think the river is a really logical and succinct sort of division between what is Wilmington, what's my neighborhood, and what's not. I think Brunswick County is essentially, I think from the metro region and from an economic perspective, I think it's, and culturally, I think it's in character much closer tied to the Myrtle Beach metro region than simply across the river in the Wilmington area.
And you mentioned earlier that Mr. Rabin won Senate District 8 in 2018. Are you aware of the percentage of the vote that he won the district with?
I know it was high, somewhere around 60%-ish.
All right, let's talk about your House district. Do you know which House district you currently live in?
18.
Who is your representative in the State House?
Deb Butler.
What is Ms. Butler's political party?
She is a Democrat.
Did you vote for Ms. Butler?
I did.
And are you familiar with the current makeup and boundaries of House District 18?
Its general contours.
So I'd like to put up on the screen for demonstrative purposes only Plaintiff's Exhibit 302. And what does this appear to be, Mr. Miller?
This looks like a map of House Districts 17, 18, 19, and 20.
And could you identify for the court, again, just approximately the area in which you live?
So it would be this blue area in District 18.
Great. Thank you, Mr. Miller. And you can go ahead and clear that.
Okay.
You mentioned that Ms. Butler won House District 18 in 2018. Do you know approximately what percentage of the vote she won with?
Also very high, also around 60%.
Great, thank you. We can take down Plaintiff's Exhibit 302. Mr. Miller, we just talked a little bit about the way that both of your districts are drawn. Do you believe that the way that they're drawn has affected your ability to participate in the political process?
I think that the way they are drawn has made it impossible for me and my Democratic neighbors to elect a Democrat, a candidate of our choice in Senate District 8. And while it does assure us, it does make House District 18 a safe district for Democrats, I think it does so at the expense of multiple safe districts for Republicans along the neighboring districts.
Mr. Miller, are there issues in the General Assembly today that you care about as a voter in North Carolina?
Currently there is a budget fight centering on Medicaid expansion that I care about. Again, I mentioned education and the environment before. As at least a fifth-generation North Carolinian, and as a lifelong resident of North Carolina, except for a couple years in school and a couple years at my first job, have benefited greatly from public education, high schools, public universities. And of course, as a lifelong resident of North Carolina, I really treasure our natural treasures. Vacationing as a kid and regularly in the Outer Banks. Just last week I was camping in the mountains. And I feel that on the whole, Democrats much more reliably, and a Democratic majority much more reliably, would protect those resources, the educational resources and the natural resources of our state.
Mr. Miller, is it your view that you are entitled to have a representative of your choice represent you in the North Carolina General Assembly?
I do not think it is my right to always, at every time, in all moments, to have the representative of my choice. I do, however, think that it is my right to have a fair shot at electing the representative of my choice, to have a realistic opportunity to do so.
Thank you. I have no further questions.
Cross-examination.
Thank you, Your Honor.
Good afternoon. Brody Irwin from Ogletree Deacons. I'm happy to be here with you guys today. Good afternoon, Dr. Miller. It's good to see you again. We met last at your deposition back in May. I'll try to be brief with you here today. I know the judges would like to get out of here, so I'll try to get right to it. You said that, I think the last thing you said when you were talking to counsel was that you don't feel that at all moments, at all times, you have a right to have a candidate who represents your views be your representative. Did you say something to that effect?
To that effect.
Okay. What you said is you felt like you should be entitled to a fair shot and a realistic opportunity to elect a candidate of your choice, correct?
Correct.
Okay. And you testified earlier that you are a registered Democrat and that you tend to vote for Democratic candidates, correct?
That is correct.
Okay. So then it would be safe to say that in House District 18, where you're represented by Representative Butler, you do in fact have that fair shot, that realistic opportunity to elect a candidate of your choice, Democratic Representative Deb Butler.
I should say, you raise a good point, and that is, it is true that the way the district is constituted, the Democratic win in that district is virtually a foregone conclusion. However, it comes at the cost of achieving a governing Democratic majority in the House much nearly impossible, if not impossible, as far as I know.
But when you go to vote for your state House representative in House District 18, you want to elect a Democrat.
I want to elect a Democrat and a Democratic majority to the state legislature.
Okay, but you personally in House District 18, your purpose when you go to vote is to get a Democrat elected as the representative of that district.
That's true, but if she's in a super minority or in a minority, it really takes away her ability to do the Democratic things that I would like her to do.
Okay. Now, I know we talked about this a little bit at your deposition in May, but I just want to make sure that nothing has changed. There's not a situation, right, where you would go to vote in House District 18 and want to cast your vote for a Republican, correct?
I would not say that under no condition, no time, nowhere, under no circumstance would I never ever vote for a Republican between now and the time I die.
Okay, but at your deposition, did you not tell me that you had never voted, that you found that you would likely not have ever voted for a Republican as the representative of House District 18?
I believe in multiple elections since my residence in House District 18, in at least one, I think multiple, there have not even been opportunities to vote for a Republican. But
that's not the question I asked you.
I'm coming around to it.
Thank you.
But as long as I've lived in House District 18, I have always voted for the Democratic candidate in that House district.
And in fact, didn't you tell me back in May that in this current climate, it would be hard for you to ever imagine a situation where you could make the choice to vote for a Republican candidate?
I would say in the current climate, it is very difficult for me to imagine that situation.
Okay.
But we all know the climate's changing.
Okay. I think we needed that this late in the day. Dr. Miller, you've donated to Deb Butler's campaign, is that correct?
Yes.
Okay. And you've never donated to a Republican candidate running for the position there in House District 18?
No, I do not think so.
Okay. So again, when you make your campaign donations to Deb Butler, it was with the goal of getting her elected?
I think my goal in donating to Deb Butler is because the more she fundraises, the more her stature rises in her caucus. And so even though her seat was not at risk, I like her. I think she's a good Democrat, a good candidate, a good representative, and I would like to see her rise through the ranks and in stature of the House caucus as well.
Can she do that if she doesn't win the position?
I suppose she could not, but I don't think that's really a likely scenario.
Okay. So is at least part of your goal when you donate to her is that she wins her position in the race there?
Certainly, but I assume from the get-go that she will win.
And you believe that Representative Butler has been a good representative, correct?
I like her a lot.
And you've been able to engage with her there in the district?
I have.
You actually live in the same neighborhood as her?
She's
correct?
a few blocks away. I see her when I walk my dog.
And you've had approximately 10 to 20 conversations with her since she was first elected?
I would say somewhere on that order of magnitude.
And I think you told me back in May, is this correct, that she always makes you feel like she's happy to hear from you?
I believe so, yes. I would say that. And I did say that, I think.
And she's, you've even engaged with her on social media, is that correct?
Yes.
Okay. Can we pull up Legislative Defendants Exhibit 186? Sir? And is this a screen grab of your tweet that you did on your Twitter account? And this is, does it reference? And in this tweet, is this a tweet where you're talking about donating to Representative Butler's campaign?
Yes.
Okay. And do you see down there at the bottom where it says Deb Butler, HD 18? And is that in fact Representative Butler's account on Twitter?
Yes.
And she's thanking you for donating there?
Yes.
Can you pull it back up? So, Dr. Miller, would you agree with me that Representative Butler, as your representative, has been fairly responsive to your needs as a constituent?
Within the extent of her ability to respond to my needs on an individual level, as a virtually powerless member of a virtually powerless minority, I would say that she has been responsive, and if only my tweets would translate directly into Democratic majorities in the House, I would be very happy.
So that raises a good point. Through this lawsuit, you're not necessarily just seeking fair districts, you're seeking a Democratic majority in the General Assembly, correct?
Through the lawsuit, I am seeking a fair playing field. I believe that a fair playing field would more likely would lead certainly to the possibility of a Democratic majority. I think an unfair playing field is what is keeping the Republicans in majorities. But I would like to divorce the question of partisanship from the question of fairness. If the Republicans could win a majority on a fair playing field, it would burn a lot less, and I think we all deserve that fairness.
Can we pull up Legislative Defendants Exhibit 198? Can we go to page 2? Dr. Miller, can you see Legislative Defendants Trial Exhibit 198 on the screen there?
I believe I see something on the screen.
And maybe part if we can just back up to that first page. Can you tell me what this is, Dr. Miller?
So, in 2016, if I'm reconstructing this correctly, in 2016, Bill Raven ran in Senate District 8, my district, unopposed. There was not even the possibility of writing in a write-in candidate. So I was faced with a choice that was no choice at all. Vote for Bill Raven or vote for no one. I voted for no one. I was so upset at that lack of choice that for a while I thought, well, if no one else will oppose Hill Raven, then maybe I will do it. And so, which I no longer have any intention of running for anything. But while I was thinking that, I applied for a potential candidate training program and from the Progressive Change Campaign Committee, and I believe that this email is effectively my application for that program.
Okay. And if we'll go to page 2 there, in that top paragraph, did you tell the Progressive Change Campaign Committee that you believed, as a North Carolinian, it was clear to you how badly that you needed to take the state legislature out of Republican hands? Do you see that?
Which line? It's in the first paragraph?
In that first paragraph, the second to last sentence in that first paragraph.
It's not just Trump unless we stop, does it? Sorry, the print is very small. As a North Carolinian, it's clear to me how badly we need to take the state legislature. That is what I wrote there.
Okay. And is it safe to say that you're using this lawsuit to again try to affect your goal of taking the state legislature out of the hands of Republicans?
I think that this lawsuit is trying to unrig a rigged process and present a fair playing field for all. I also think that when that happens, there is a chance that Democrats can be in the minority, because I think an unfair partisan gerrymander, a rigged system, is what is largely propping up the Republican control.
Now, Council a minute ago asked you about House District 18, and I think you testified that Representative Butler won with something like 60% of the vote. Is that, do you recall testifying to that?
I believe that's correct.
Okay. And as we discussed at your deposition back in May, you're aware that beginning in 2004, under the legislative plan that was drawn by the democratically controlled General Assembly, House District 18 elected a Democrat, Thomas Wright, with 64.8% of the vote.
I don't have a clear memory.
64.8% of the vote.
If you represent that as true, I will accept it.
Did you know that in 2008, House District 18 again elected a Democrat, Sandra Hughes, with 67% of the vote?
If you represent that as true, I will accept it.
Did you know that in 2010, House District 18 elected Susie Hamilton, another Democrat, under the same map with 57% of the vote?
I will take your word.
Okay. Do you think it would be safe to say that over the last decade, House District 18 has consistently been represented by Democratic candidates who win with a comfortable margin?
That seems to be the case as you described it.
Okay. And you've never filed a lawsuit to challenge your House district prior to this one, correct?
No.
Now, with regard to your Senate District 8, you claim that it's a crack district, is that correct?
With the caveat that I might not have the full technical understanding of what the term crack means, it generally, I believe it's the case as I understand it to be.
And unlike the challenge you're making with your House district, you actually want to be represented by a Democrat in Senate District 8, but you're not. Is that correct?
I would like the chance to possibly be represented by a Democrat in Senate District 8.
And are you familiar with the amended complaint that your attorneys filed in this case?
I have seen it. I have not. I cannot say I understand every page of it.
Okay. Can we pull up the amended complaint, page 13, paragraph 39? All right, and can you see that there on your screen, Dr. Miller?
Yes, sir.
And in paragraph 39, does it say Senate District 8 is a heavily Democratic area in Wilmington where Dr. Miller resides, is extracted from Senate District 9 and placed in Senate District 8 to waste the votes of those Democratic voters in Senate District 8 and make Senate District 9 as competitive as possible for Republicans? Did I read that correctly?
Well, the text was flashing. I trust you probably did, but I couldn't follow it line for line because there was movement of the text.
Now, that paragraph makes it seem as if it's drawn, if that you're taken out of Senate District 9 to make Senate District 9 a Republican district. Were you aware that that Senate district actually elected a Democratic candidate in 2018?
I was aware that Harper Peterson won Senate District 9. The funny thing is, I first met Deb Butler when she was running for Senate 9 in 2012. I went to 2 blocks up and 2 blocks over to a fundraiser for her. And then later I went to vote for her and found that she wasn't on my ballot. And that's when I first learned that I was in the Wilmington Notch. And the reason that exists, as I understand it and as I believe, is essentially a blue stone is taken out of Wilmington and thrown into a sea of red where it sinks to the bottom.
But the constituents there in Senate District 9, they actually elected a Democrat candidate in 2018 and actually unseated a multi-term Republican, correct?
I believe the incumbent was multi-term. Well, of course, by definition, yes.
So now you brought up the notch a couple of times there in Senate District 8, the Wilmington Notch, as you're calling it. Can we pull up Legislative Defendants Exhibit 191? Dr. Miller, can you see that on your screen there?
I can see it.
Is this a map similar to what your attorney showed you a minute ago that shows you Senate Districts 8 and 9?
It is a map of Senate Districts 8 and 9 and some other, it's zoomed out more so there are other counties. Whether or not it's similar is a little bit hard for me to say.
And I should have had my colleague pass out Legislative Defendants Exhibit 190 at the same time, and I apologize for that. But where that blue dot is on 191 that you're looking at right now, is that roughly about where that notch is, where you reside?
From this distance, I suppose that dot is on my house. It's hard for me to say with certainty.
We'll be quick. Legislative Defendants Exhibit 191 up there for him. I'm sorry, 190. This is a zoomed in version of what you've been calling the notch. Is that correct?
It appears to me to be correct.
Okay. And where that blue dot is that approximately where you reside there?
If it's on the corner of 7th and Nunn, then it is approximately where I live. I'm sorry. Okay, yeah, sorry.
Now, earlier when you were talking with your attorneys, you said that other than gerrymandering, you couldn't think of any reason for that notch to be where it is. Is that correct?
That's correct.
Okay. But you're not an expert at map drawing?
Certainly not.
Okay. And you've never drawn any legislative maps?
Certainly not.
And you certainly didn't prepare any alternative maps in this litigation?
I did not.
Okay. And in fact, you're not familiar with the criteria, all of the criteria that the North Carolina legislators were forced to consider when they were drawing the 2017 plan, were you not?
I am not familiar with all the criteria that they had.
And are you familiar with the fact that New Hanover County couldn't be wholly contained in one Senate district?
I believe you told me that during the deposition.
As a result of population requirements.
I accept that as true on your word.
So did you know that some population had to be removed from New Hanover County and put into a neighboring Senate district?
If you represent that is true, I will accept it.
So if the notch wasn't drawn where it captured you, you don't have any opinions about where it should have been drawn, do you?
I cannot propose a new map.
Give me just one moment, Your Honor.
Yes.
Mr. Branch? Mr. Tolchin?
No.
Redirect?
No further questions. Thank you.
Thank you very much. You may step down, sir. Right. Let me check. There was one topic I wanted to go over regarding publication of documents on the website. There's no need to do that on the record. I just wanted to clarify a couple items for that. Are there any other matters that we need to take up before we recess on the record?
Just very briefly,
Yes.
Tomorrow we'll begin the testimony of our experts. Those examinations will rely heavily on charts and figures that we will want Your Honors to be able to see, and I appreciate you only have one pretty small screen up there. So we've asked the great technology people here are going to bring in a large screen that we will display so that you'll all be able to see the charts.
Okay, that'll be fine. Hopefully it'll be in a place that's not blocking.
We're going to come at 8 o'clock tomorrow morning with the tech person and try to find the best place so that there's we don't create any more obstructed view seats than we have to.
All right. Very good. Well, let's be in recess then, and counsel, if you'll stick around, we'll just have an off-the-record conference about some documents, make sure that we're all on the same page about what is available on the public website. We'll take care of that off the record. So we'll be in recess until 9 o'clock tomorrow morning.
Be reports for recess till 9 o'clock tomorrow morning. God save the state. It's on record.